Mr. Jamil, tell me.
Yes. So from the main place activity 12, that is the first hearing case. I have instructions to refer this case to.
Mr. C.T. Jamil, the learned senior counsel, assisted by so and so, submits that he has instructions to withdraw the instant petition. Mr. Imsong, the learned additional advocate general, appears for the state of Nagaland. Taking into account the above, the writ petition stands closed on withdrawal.
Mentioned item number 7. Lordship, in this case, this is the first case right after the motion. So I need to receive the instructions. So
We'll see when the matter reaches.
Lordship,
We'll see when the matter reaches.
The petitioner was pending liberty and special application. So, where the
You want to? You want to withdraw?
the petitions on the conversion.
Madam, I'm very difficult for me to understand what you're saying.
Your last order said in March,
Ah.
the petitioner was pending liberty. We had a search for the so the petitions under the petition.
So you have not filed some document. We'll see when the matter reaches.
From the supplementary cost list for motion, item number 14.
Yes.
The landmark, the MOA was executed between the state government, the central government, in the presence of the Home Minister Amit Shah, my lord, and the representative of the ENPO, that is the Eastern Nagaland People's Organization. They consist of 8 tribes and are spread across 6 districts in the present Nagaland, my lord. Now, under that, from the Nagaland Territorial Authority was to be created. And then an interim under clause 5 of the memorandum of association entered upon on 5th of February 2026, madam. That is only a few months ago. Under clause 5, it is provided that an interim body consisting of 13 members is to be selected, my lord. If I may be permitted to take my lord to page 29, my lord.
Yes, framework.
The governor shall nominate an interim.
This is the
council.
memorandum of agreement between the government of India, government of Nagaland, and the Eastern Nagaland People's Organization.
Yes, ma'am. Yeah, Eastern Nagaland.
Yeah, what does it say? To establish a unique self-governing territorial authority based on the spirit of so and so to provide for democratic, decentralized so and so. Now,
Under that, my lord, under the MOA at page 29.
the elected and nominated members will normally hold the office for a period term of 5 years.
Yes, madam. But
Yeah.
prior to that, prior to the election, an interim committee was to be put in place by the state government, and the committee members was to be recommended by the Eastern Nagaland People's Organization, and there are also some
Where is it? Where is it mentioned?
Clause 5/29, my lord.
5 point?
5.1 and 5.2 is relevant, my lord.
The governor shall nominate an interim consul not more than 30 the affairs of till it is constituted through elections. The members will be recommended by in consultation with the what is ENPO?
Eastern Nagaland People's Organization, my lord.
In consultation with the respective tribal councils
Yes,
and submitted to the state government for approval of the governor. The governor may, on the recommendation of the state government, nominate not more than 4 elected representatives, MP 1 and 3 so and so from the FNT area as advisors to the interim council for coordination purpose with so and so. So there will be an interim council, how many members?
There are 2 members, my lord, and 4 to be elected representatives, my lord, to be nominated by the.
So, 4 will be nominated by the governor.
Yes, my lord. That is
Those
true.
will be 1 MP and 3 MLAs.
Yes, my lord.
There's no quarrel with that.
No, my lord.
Now you are not MP MLA.
No, my lord.
Okay, so you
No,
have no
no, my lord.
business in
Yes,
that. So
okay.
you are only on the other aspect.
Yes, my lord.
The members to recommend the remaining 9.
Yes, my lord.
As regard the remaining 9, the
No,
members will be recommended by the ENPO
Yes,
in
ma'am.
consultation with their and then submitted to the state government for approval of the governor.
Yes, my lord.
Now they have made a framework. Where is that framework?
Yes, my lord. And
Framework for selection of
Yes, sir.
recommendation
Formal.
of the objective must be an Eastern Naga by
82, my
blood.
lord.
Individual must possess at least a bachelor graduate's degree from a recognized university. Individual must have attained the age of 40
Yes, ma'am.
years.
Yes,
The
ma'am.
individual must not exceed 65 years.
And
So
approved by the
40 years.
Yes, my lord.
What is your age?
35, my lord.
So you cannot.
Yes, my lord. And whereas the decision number 2, my lord, is above 40.
So he can very well do. He is not
Yes,
a
yes, yes, ma'am.
petitioner number 2 is not a person aggrieved.
Yes, my lord.
So petitioner number 2 cannot maintain the instant writ petition.
It does of the general public, my lord. And
This is not a PI.
my lord.
No. So
But-
petitioner number 2 goes.
My lord,
So
that-
petition number 1's case is there.
Yes, ma'am.
So we strike off petition number 2.
Right.
Yes. Now as regards 35.
Yes, my lord. Now, my lord, I am from the Titir tribe. PNPO consists of 8 tribes, my lord.
You
So-
don't, from that tribe, there is no person who is 40 years.
40 years, no, my lord.
There is not a person from Tiki tribe who is 40 years.
No, my lord. Now,
Mr. Imsal, is it possible? There is no person from the Tiki tribe who is 40 years. Huh? Then
well, lordship, now again, lordship.
they have made this framework. What is wrong with it? Why should we interfere?
Now, my lord, again, lordship, the copy that we have received, that Titir tribal council have received, here, the ENPO has given that for us it will be 42 years, not 40 years.
Where?
In the next annexure 5, my lord. So that is the copy that the other tribes have received and the copy that we have received. It
Where?
differs on the edge. Page
This is
67.
different.
Yes, page 67.
Earlier is, where are you getting this part A, page 62, annexure 4 from? There's no date.
Yes, my lord.
Is this framework made under, by whom?
By the ENPO, my lord. It's
Huh?
another close organization, my lord. And
ENPO,
yes, my lord.
they have made it.
Yes, and the meeting minutes I have already annexed, my lord, at annexure 2, my lord. And based on that meeting minutes, my lord, this framework was issued. So at page annexure 5, page 67, the relevant portion is at page 48, my lord.
Where? Age, 42 years.
7 years, my lord. Here,
So now they have made it 42.
yes, my lord.
Earlier, no, I understand one thing. Tell me, what is part A? Part A must be a part from somebody.
Yes,
Something, where is that part, something? So it has been mentioned somewhere in the main agreement. Why is it mentioned as part A?
Lordship, there is also part B. Lordship.
Understood.
Yes.
Why there is part A? Part A always has to be a part of somebody.
Yes, my lord.
Is a part of what?
This is part of the framework, my lord.
So, no. So you have enclosed a part of the framework.
Framework for selection and recommendation of members of the FLT Interim Council.
No.
This has been divided into
Mr. Sendianga, kindly come to page 62.
three parts, my lord.
Part A.
Yes, my lord.
Part A must be a part of something.
No, my lord. Part A is part of this framework for selection and recommendation of members
Understood.
of.
Now, why do you mention as part A, part B, part C?
Part
Because you are identifying the framework.
Oh, my lord. This
Yes.
kindly travel to page 70, my lord.
Page
70.
70.
Yes, the same framework. This is part B, and again the same framework. Very next page, page 71 is part C.
Understood. So
yes,
this is a checklist for criteria.
yes, my lord.
Okay.
Yes.
So these are there.
Yes.
Is it a part of the original agreement?
No.
So then how does it come into part A, part B? Show me the forwarding of this.
For instance, this dated 5th of February 2026, my lord. Whereas
5th of February 2020. Wait.
Yes, my lord.
Invitation for submission of names by FMT so and so clearing. This is being written by ENPO.
Yes, my lord.
This person has written. Now, with reference to the Iman, the Eastern Nagaland desires to recommend names of interim members to the government for the formal. In this regard, you are requested to submit the shortlisted names on or before so and so for further submission of the year. That all tribunal to take the confidence of the respective frontal bodies, elected members, including so and so. Literally is annexed. Okay, so this is a part of that. 5th of March 2026. Annexure 3. Annexure 3
My lord.
is the forwarding for A, B, and C.
My lord.
Isn't it?
Yes, my lord.
So therefore, Annexure 3 has been issued by them.
Yes, lord.
ENPO.
Yes.
Now,
After a meeting being conducted on 4th of March, the meeting minutes I have annexed as annexed.
so now this was this, which made it 40 years.
Yes, lord.
Now, how does this come in? The 6th of March. Earlier it was 5th of March.
Yes, my lord.
Why it is 6th of March comes in how?
Lordship, I have no idea.
Okay, you also have no idea. Let us ask them also. Isn't it? You find it out.
Here, my observation is such Annexure 2, that is, ENO travel presidential meeting, which was held on 4th March 2026 at company. And here, regarding the effects of the age, minimum and maximum, that is the resolution.
No, therefore, this is the minutes of the meeting.
Yeah,
So they have put it at 40 and 40, 65.
Yes,
No, but I don't have I am not able to understand why you have put 42 later on. Kindly see, 4th of March, there is a decision that the person will be from 40 to 65 years, isn't it?
Yeah.
Page 56. Now at page 62, 63, you see it is 40 and 65.
yes.
No problem with that. 2.3.1 and 2.3.2. Now, on 6th of March, why it was changed to 42 and 65?
My concern is about whether this petition is manageable or differences.
Yes.
No, it is annexure 13, that is bill only,
Annexure
13.
1.3.
And whatever age, whether minimum.
Where is Annexure 13?
Yes, is a
Frontier
bill only.
Nagaland Bill.
Yes, my lord, I don't know the deal.
And again, now the petitioner is seeking the resolve the grievances to this more about the minimum maximum age. That is your own arrangement. So while arranging or while minimizing or discussing about this.
What is the qualification given here as per the bill?
If they bill, there's no age at all. Having a specific definition of the
Age.
minimum and maximum age. But now, at this age, what do I do this is kind of intake.
Chalo,
Yes.
we dismiss it.
No, my lord.
And age, about the minimum and maximum age, that is the only age. That is the only age.
No, lordship, I strongly disagree, lordship, because here, lordship, when the act is silent or when the MOU is silent, the education qualification or the age relaxation, the minimum age, maximum age, it must be.
You get hold of another person who is between 40 and 41. As of now, it cannot.
Now, lordship, now,
So we dismiss it.
now, as per the other statutes, my lord, say for example, the other village councils act, we have, in order to be selected as a village council member, a person is to obtain factors. Now, under the Nagaland Municipal Act,
No, Mr. Sanketa, you have to understand, this is an interim council for a period of almost 1 year till
Yes.
the elections comes in.
yes, my lord.
So they would obviously like a person who is having a particular age. Now, just for example, do you have an age put out there to become an MP and MLA?
Lord,
Isn't it?
yes, lord.
You have a particular age being put out there as a for MPL. It is absolutely within the discretion. Now, this is a minute of the ENPO, which consists of your tribe also.
Lordship.
Yes.
Yes.
So in these minutes, it was decided from 40 to 65.
Yes, my lord, in fact.
Now, wait, one person is 60, who is obviously entitled to, there is no problem with that.
My lord.
The other is 35, who is not entitled to. So you get hold of somebody, why there is a change from 40 to 42, a person who is between 40 and 41, and again approach this court,
No, lordship. Lordship,
isn't it?
in my opinion, my lord, in my humble lordship, the minimum age has to be fixed in consonance with the other provisions.
No, this is an
That
interim
is,
council.
provisions are.
No, this is an interim council, nothing to do with all these
Provisions
things.
under the Constitution of India, my
You
lord,
see,
in order to represent.
this is a case of where a person is being nominated. This is not an elected body.
Yes, lordship.
So the person will be nominated. So they want some person who will be between 40 and 65.
Lordship.
So between 40 and 65, this is a case of nomination. Once the elections come in, you have to have the election. This is normally for a period of 1 year.
Yes, my lord.
So if it is after that the elections comes in, then obviously keeping it at 40 and 65 may not be proper, taking into account the other aspects. Where a people representative now, we have the Gen Z
My lord,
aspect
my lord.
of that, which
I'm
is
not-
being very famous.
I'm not saying that, my lord, the age has to be from till 18 years, my lord. I am only suggesting that lordship as per the Article 84 of the Constitution of India, where a member of parliament can be, Lok Sabha can be 25, Rajya Sabha can be 30, my lord. So similarly, my lord, the age may be fixed, my lord.
By
in
the-
terms of Article 173.
No, this
and Article
for an
54.
interim arrangement, this court is not going to interfere. For an interim arrangement, this court is not interfering. You want that a person is affected
not-
between 40 and 42? Very well, you may have a case.
Lordship, I am not here before this honorable court praying that, demanding that I have to be elected or selected.
Absolutely no,
only-
you have no.
I
No,
am saying
petitioner
that
number
lordship-
2 can very well.
Yes,
Did
yes.
he submit his nomination?
Yes, of course, of course.
Then why is he challenging?
Now, lordship.
Something is abuse.
lordship,
Why
I
has
want
the
to say that
petitioner,
I have
Mr.
the right.
Sanjay, why the petitioner number 2 has approached this court?
I want petitioner number 1 is only saying, my lord.
Forget about
he
petition
has a
number
right
1.
to
Now,
continue.
why has petitioner? He wants to stall this interim council.
No,
Yes.
no.
Why
no,
will
my
he
lord.
otherwise come? Are you
No.
asking for a stay?
Yes, my lord.
Then why has he come? He can very well participate. He can very well participate. His age comes
But
within the ambit
despite
of
that,
it.
lordship, the petition will survive even without the petition number 2.
Fantastic. Then the petitioner number 1, the petition does not survive because your tribe was a part of the ENPO. They have discussed and made it 40 to 65.
Lordship, in fact, we have written my tribe president, ex-former president, the former vice president, my lord, we have representation to the ENPO president, my lord, legislating this minimum age also, because in the particular tribe.
It's a democracy. Isn't it a case of a
In the
democracy?
particular tribe, my lord, some people.
Tomorrow, just for example, in the parliament, some parties do not like a particular amendment to pass through. The other parties very well like it, unless you show that there is a violation of Article 14. Well, why should this court interfere under 226?
When the MOA is silent, lordship, the minimum age must be fixed, my lord.
No, in fact, what they have done is it's a very transparent thing which they have done. The power is being given to nominate. There will be total 13 members.
Yes, sir.
This nomination will be made by ENPO
Lordship.
to the state government. The state government will approve it,
Yes, sir.
and then the governor will nominate these 9.
Yes, sir.
And apart from that, there will be another 4.
Fine.
So these 4 will be there who are MPs, 1 MP and 3 MLAs. So that is another thing.
Yes.
So this is the power which is being given to the ENPO. They could very well say that, okay, we don't do it, we do it by ourselves. Forget about that. Age, no age, whatever may be. But they have gone into a transparent thing by framing a minutes of the meeting out there for holding that we'll have from 40 to 65. Now, you were a part of that same decision-making process. You being aggrieved, you cannot come before this court.
Lordship, I am saying that, lordship, even if it is transparent, lordship, it may be illegal.
Why is it?
Somebody can do an illegal act, my lord, in a very transparent.
Why is it illegal?
Illegal in the sense, lordship, because it is unlawful, because it is not.
Why is it unlawful? Isn't it? Do they have not the power?
Democratically elected representatives requirement for democratically elected representatives under the Constitution of India, under the Municipal Act of Nagaland, my lord, under the Village Council Act of Nagaland, my lord.
But those are elections.
Yes, lordship, I understand.
This is not an election, this is a nomination.
Yes, lordship.
So therefore, they have put it in this pattern that they have decided amongst themselves. This was not an exercise required to be done. They want to be transparent, thereby asking everybody to.
Lordship,
This court is not going to interfere. Why issue a notice? No notice, Mr.
lordship,
Imsam.
a person who is an interim council member, my lord, he, lordship, has also a strong foothold, lordship, to be elected for the next election, lordship.
Fantastic. Whenever he comes, you let him become. Why? You want to be first nominated and then influence your voters for the elections?
That may be done, lordship. Somebody may do it.
No,
lordship.
you
That's what I'm
cannot.
saying, lordship.
That cannot be.
Now, which is why, lordship, a person who has interest to serve the people, lordship.
So we
And
dismiss.
if he is above 30 years, lordship, he should be given. I'm not saying, my lord, he must be selected. I am saying that he must be given a right to be considered for selection.
We dismiss. Mr. Imsam, we dismiss it.
Because fixing of the age, that is a good arrangement.
So we dismiss it.
And you see that regarding the age, there that meeting held on 4th March 2026.
That is what I've
It's
seen.
very crucial. And the petitioner representative was from.
Mr. Yangavati, you appear for petitioner respondent number 1. Take a dismissal in the morning. Isn't it?
The union has nothing to do here. The union has nothing to say.
The union is made a party.
Yes,
They are the respondent number 1. So there is a tripartite out there. We'll look into it. We'll let us dismiss it.
Because, my lord,
It's a.
I give you the liberty for a person who comes under 40 to 41. Otherwise, I dismiss it.
lordship, lordship,
Dismiss. Heard Mr. Santianga, the learned counsel, appearing on behalf of the petitioner. Mr. Yangavati appears on behalf of the respondent number 1. Mr. Intim Song appears on behalf of the respondent number 2. First stop.
I only pray that, my lord, the grounds that I have taken in paragraph 13 of
No, I'm not. The present petition has been filed by 2 petitioners. One petitioner is 35 years of age and the other 60 years of age. Gusto. A memorandum of agreement was entered into by and between the Government of India, the Government of Nagaland, and the Eastern Nagaland People's Organization, bracket for short, ENPO. In terms of the said agreement, a self-governing territorial authority would be constituted in the spirit of Article 371A of the Constitution for autonomous council of authority to enable the people of the Eastern Nagaland region to fulfill their social, political, economical, educational, cultural, and linguistic aspirations. First, in terms of the said memorandum of agreement, there would be a constitution of the frontier Nagaland territorial authority, which would have legislative, executive, and administrative autonomy. Clause 3 of the agreement stipulated the manner in which the Frontier Nagaland Territory as well as the Frontier Nagaland Territorial Authority would be constituted. In terms with clause 3.10 of the Memorandum of Agreement, the state government have been endowed the power in consultation with the FNTA /Interim Council and with the approval of the governor to make rules as regards various matters for smooth functioning of the FNTA. Where is the clause? Interim Council?
My lord, page 29. Clause 5.
Gusto. Clause 5 is relevant for the purpose of the present dispute. And as such, the clause 5 of the Memorandum of Agreement is reproduced hereunder. Madam, you will find it at clause 5, page 29, 5.1 and 5.2. From above quoted clause 5.1, it would show that the governor shall nominate an interim council consisting of not more than 13 members to look after the affairs of the FNTA till it is constituted through elections. First, out of these 13 members, 9 members would be nominated upon recommendation by the ENPO in consultation with the respective tribal councils, and such recommendations shall be submitted to the state government for approval of the governor. As regards the remaining 4 members, the governor may also, on recommendation of the state government, nominate not more than 4 elected representatives, of which there should be 1 member of parliament and 4 members of the legislative assembly from the FNT areas as advisors to the interim council for coordination purpose with MHA and the state government. Clause 5.2 further makes it very clear that the tenure of the interim council cannot exceed more than 1 year, during which period the FNTA shall be held. Elections to the FNTA shall be held. First, for the purpose of recommendation to be carried out, for the purpose of making the recommendation, the ENPO, which is an organization of various tribal bodies, held a meeting on 4th of March 2026. In the same meeting, various aspects were discussed amongst the various amongst the 8 tribal presidents, along with the 8 tribal presidents, as to what should be the basis and how the recommendations were to be made. These minutes, the meeting was minuted by a minutes of the meeting held dated 4th of March 2026 under the signature of the secretary of the ENPO. Relevant herein is clause 4 of the minutes of the meeting held on 4th of March 2026, and more particularly to subclause Roman 3, which stipulates as to the age, which is age of the persons who would be nominated. Clause 4 Roman 3 of the minutes being relevant is reproduced hereunder. Page 56. From a perusal of the above quoted clause, it would show that it was mutually decided in the minutes, in the meeting of the ENPO, that the age would be between 40-65 years, meaning thereby the individual must have attained the age of 40 years and above, and the individual must not exceed 65 years of age at the time of appointment. First, pursuant thereto, a communication was issued on 5th of March 2026 to the president of various tribal, what do you say these tribal communities or tribal authorities?
Tribal unions.
Tribal leaders. No. KU is what?
KU is Konyak Union.
So to various tribal and TTCs.
This is Tikio Tribal Council.
So to various tribal
Yes.
bodies.
Yes, ma'am.
Bodies will be right. To various tribal bodies. Wherein the tribal bodies were requested to submit the shortlisted names on or before 10th of March 2026 for further submission to the competent authority. This communication dated 5/3/2026 contained was the enclosure to the communication dated 5/3/2026 had 3 parts: Part A, Part B, and Part C. Part A categorically mentioned the framework for selection and recommendation of the members of the FNT Interim Council. Full stop. The petitioners herein are aggrieved by clause 2.3.1 of party, inasmuch as it is stipulated therein that the individual must have attained the age of 40 years. First, it is also seen from the records that pursuant thereto there is another framework for selection and recommendation of members to the FNT Interim Council dated 6th of March 2026, wherein clause 2.3.1 have been modified, whereby the minimum age have been fixed at 42 years and above. The petitioners herein being aggrieved by the insertion of the lower limit of the age at 42 years have approached this court by filing the present writ petition. First, this court have heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. Mr. Im Tim Song, the learned Additional Advocate General of the state of Nagaland, had submitted that the instant writ petition is not maintainable, taking into account that the petitioner number 1 have not attained the age of 40 years. And as regards the petitioner number 2, he is well qualified, taking into account that his age is 60 years. The learned counsel learned Additional Advocate General further submitted that it was a decision of the various tribal bodies in the minutes of the meeting to have the age between 40 and 65 years. And therefore, the petitioner herein cannot question the same, as the petitioner's tribe was duly represented in the said meeting. Apart from that, the learned Additional Advocate General submitted that this is only for an interim council, and as regards the election, the age would be as per the mandate of law. First, this court have given an anxious consideration. First, and is of the opinion that the petitioner number 2 is not a person aggrieved to challenge clause 2.3.1 inasmuch as, in terms with the memorandum, in terms with the framework for selection and recommendation of the members in the FNT Interim Council, the petitioner number 2 is qualified, is eligible insofar as the age is concerned. Now, coming to the question as regards the petitioner number 1, he claims to be 35 years. First, it is the very decision of it is the very decision taken in the minutes of the meeting dated 4th of March 2026 that those persons that amongst the various tribal bodies that age for making the recommendation would be between 40 and 65 years. First, the petitioner number 1 in the instant proceeding, having not even attained the age of 40, cannot question the changing of the age by the framework of for selection and recommendation of the members to the FNT Interim Council dated 6th of March 2026. First, Considering the above, this court does not find that the petitioners herein have the locus standi to challenge the petitioners herein a person agreed with in terms with Article 2 to 6 of the Constitution to challenge clause 2.3.1 of the framework for selection and recommendation of members to the FNT Interim Council party. Accordingly, this writ petition stands dismissed. However, this court is not inclined to impose any cost. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not prejudice or preclude a person between the age of 40 and 41, 40 and 42, to approach this court challenging the framework for selection and recommendation of members to the FNT Interim Council dated 6th of March 2026. Inasmuch as clause 2.3.1 have of the said framework have enhanced the age of minimum qualification to 42 years, though it was agreed in the meeting dated 4/3/2026 to be between 40 to 65 years.
For admission, item number 1.
Now, Mr. Santiago, get hold of a person who is within 40. You have a case for 42 to 50.
My lord. Otherwise, my lord, somebody who is elected as a member of the legislative assembly, he will be 25.
25 for election, very
And
good.
he can be nominated, lord. He can be nominated.
Who? No, you see, when the tribal bodies are there, you have to go by there.
Yes.
Yes, whose matter is this? I think
Yeah.
service matter. What is this? Yes, Mr. Joe, what are you challenging?
Mr. Chair, I have taken the submission back on the case of theoretical more question. So this matter will be given to you tomorrow. Friday.
Illegal.
I have taken submission back.
Joint director.
So the case of
My lord, government has filed affidavit. And has taken, I believe, not less than 20 times adjournment.
Maintenance. It's a case of RICO quo warranto, that he does not have the basic qualification. That's your
My
case.
lord, the lordship, they have jumped from the training wing to employment out of Washington.
You belong to the employer.
Employment.
employment wing and the other Mr. Mujoy belongs to the craftsman wing.
Yes. No question of I jumping over the employment wing. There are two parallel wing, craftsman and employment. So I'm in my own wing.
Huh?
I'm in my own wing.
You are in craftsman.
Craftsman, yes.
They say that craftsman can become maximum to the case of a deputy director.
Principal.
Deputy director.
Deputy director, provisions there, but there's no sanction.
Rule 3. Under Rule 3, they will both can go up to the director. The rule provides. The rule provides.
Mr. Imsong, you have no problem. Mr. Mujoy is going to argue. Here he is asking for a quo warrant. A quo warrant is a writ which the court is going to issue if a person does not have the qualification. He's not asking for a writ of. So therefore, we are to see whether he has the qualification or not. And it is he who has to satisfy.
Also, in the meantime, I have some article in the court rules.
Oh, please, you be there in court number 2. Let Mr. Mujoy argue and Mr. Joe argue.
Will be allowed to give for.
Please, you are at liberty to go. I'm not giving you are at liberty.
Was specific, what was made to the state exponent with regard to when it comes to the order. On 21/11/2025, okay.
21/11/2020. To promote petitioners, I claim the petitioner are deputy directors in the employer. They claim that the joint director post to which has been promoted belongs to Mr. Mujoy so and so had reduced the Nagaland employment and so and so. Provide the national is forced to join the vehicle form. Employment.
They will refer.
That they are a joint director. So, no, therefore, if the rules stipulate that a person can be a joint director from the craftsman wing,
Yes,
then the writ of quo warranto cannot be issued.
rule 3.
So then the writ of quo warranto cannot be issued.
No,
It's a simple case.
yes.
At all.
No, Lordship, all this while, the joint director post, which the employment wing are holding, is a post that belongs to us. That was upgraded, Lordship, and they are holding one post.
So let us see the rules.
Lordship.
Please, you are at liberty.
There.
Okay, it's certainly a last question. Lordship, we can come to rule 3. Page 3.
It is quoted at page 47 of the writ petition.
What's it? Yes.
Yes, what is it?
Lordship, we can come on page 3 of the service rule. This is an extract of it. In the next service rule.
Page 3.
Yes, rule 3. Lordship as follows.
Constitution, yes.
Constitutional service. The service shall consist of following wings, headed by director and under the wing of which following categories of posts shall be considered. Lordship, you can see the director post, that is salvation wing. Below, employment wing, Lordship. A, B, craftsman wing.
And
It's not a question of I jumping into their wing, Lordship.
no, so therefore, joint director post can be held by a craftsman wing. You see, Mr. Mujoy,
Lordship.
the scope of a quo warranto writ is a different. It's not a certiorari writ. It's not a certiorari. Certiorari writ is when you set aside and quash a thing if it is done illegal or whatever may be.
Yes.
Quo warranto is a writ where you issue when a person holds into a public office although he doesn't have the qualification. So therefore, it dispenses with the locus standi. So therefore here, if the post can be filled up by a craftsman wing, that's all. I'm not going to see as to whether you have been rightly done or not, it's a different thing.
Sure. Yes.
Now, the moment you are a craftsman being can become the joint director. Patents.
Yes. Now, Lordship, all of us are.
Now, I'm satisfied with your case. Let Mr. Joe argue now. How is it possible? Yes, Mr.
I please stop. My lord, the petitioner, I have filed this weekly in the nature of government, so out the permanent form. Because he has transposed, I will just. He has transposed from training week to employment. Under the rules, rule 1998. There are two separate categories under the same time. One is employment week, one is training week. And the worship will see the powers and functions of the employment wing is purposely for administration. Training wing is to teach the ITI.
But Mr. Joe, you agree that response number 5 is from the training wing?
Correct.
Okay. Now you are asking for a writ of quo warranto
Correct.
to the effect that he could not have been appointed to the post of joint director.
Yes, ma'am.
But what do you say about rule 3?
I'll come to that, ma'am. I'll explain it. I have prepared for this. Lordship, before that, I'll just show the chart, how he has come to us. After that, I'll read out. Lordship, Lordship is asking about the rule. My lord,
Yes.
Lordship, I'll just show the chart on it. Or rule 3.
What is the name of the private respondent?
Alongside.
Huh?
Which? Alongside. Engineer H. Alongside.
Respondent number 5.
Respondent number 5.
Yes, initially entered as vice
The chart,
principal.
the chart, my lord.
Yes.
The chart given below will show that the post of joint director held by person number 5 arose from the employment week and held by the cadres from the employment week. Particulars. Initially, Mr. Liwan Panyak appointed interviewer employment week. Date of appointment 4/09/1984. Then the document is annexed 2, page 2. Now, Liwan Panyak was promoted to the post of junior employment official on 16/07/1991, annexed 3, page 50. Then he was further promoted to the post of district employment official while promoted at 18/05/2000, page 81. Then promoted to the post of regional employment official from employment week on 14/06/2016. Then annexure 5 in my affidavit reply, page 21. Then promoted to the post of joint director at employment week on 27/09/2019, annexure 4 in my affidavit reply, page 24. Then the same official, Liwan Panya, he retired as joint director employment week on 18/10/19, annexure I into my affidavit reply to the affidavit, page 8. Then how this post, how the vacancy was filled up by an official called Engineer Gauhati, who is from training week.
No, Mr.
Yes.
Mr. Joe, therefore I said the scope of quo warranto is very limited. Whether it was illegal on his part by which he was appointed as a joint director is a different aspect which a tertiary jurisdiction can look into, but not by way of a quo warranto. I'm not on that. Quo warranto is that a person concerned who does not have the qualification is being brought into and appointed to a public post. We require only 2 things to be proved in a quo warranto. First, that the office he is holding is a public post.
Correct.
1. Secondly, he does not have the qualification to become in that. I'm not concerned whether it is illegal he has been brought. No.
There is
Whether he has the qualification. The qualification is, can a person who is in the training wing can become a joint director? That's it.
Yes.
Short.
For that matter also, he has no qualification.
Why?
Also from such school. The entry point, qualification. My lord, the case is this. Under the rule, rule 3, from both wing, one can become director. Rule 3 provides. Rule 4 is for the strength of the candidates. Rule 5 is the method of recruitment. Now, rule 3, rule 4, rule 5, these are the provisions made in the rules. Now, Lordship will see then come back to Schedule 1, Schedule 1A. Schedule 1A is for the employment.
Schedule
1A, page 12. Lordship, this is the total strength of the employment. Now, employment director up to employment official class 2, this is the starting point, entry point, for as far as class 2 is concerned. So this is the strength. So this is Schedule 1A. Now coming to Schedule 1B, right, Rule 4, meaning strength, total strength. Now for the Lordship will see on the right side, Nagaland Craftman Training Service Rules. Now, their last promotion as per the service rule is deputy director. Then to become deputy director, there has to be principal senior grade. Then principal, vice principal is the entry point for that class 2 man. Then also Lordship, Lordship is talking about the rule of the qualification man. My lord, Schedule 2A. Schedule E, 2A is the method of recruitment and qualification man.
Let us read rule 4
Yes,
first.
Rule 4.
Yes.
This is the total strength. Strength of the candidates.
Yes.
Page 4. Rule 4. Page 4. Page 4, rule 4. Strength of service. Add the number of posts and permanent as well as temporary under each wing and category shall such as may be determined by the government from time to time. B. On the commencement of these rules, the strength of the service permanent as well as temporary together with the scale of pay attached to the post has been shown against each in Schedule 1A, Schedule 1B, provided the members of post both permanent as well as temporary under each wing by the government. So this is total strength of both sides. So now, if we read the Schedule 1A, so this is the strength. Schedule 1A is the strength for the employment.
Oh. Now the problem lies here.
My lord.
There seems to you have challenged the rules.
No.
Who has changed the rules?
They challenge. That was dismissed. The same group petition.
Now you see, Mr. Mujo, what you say here, you are only referring to Rule 3. Now, Rule 3 they have mentioned as Grade 1, Senior Grade 1, Joint Director, Deputy Director, so and so they have mentioned. Now, kindly come to Rule Schedule 2A, capital A.
Yes. Of course, before going to the.
No, wait. Joint Directors, how a person can be promoted?
Lordship, Lordship, can I come to the election 2 of my act? There's a lot of issue.
There's a challenge.
Challenge this one.
Where? Of your?
My act. Respondent number 5. That will clarify this portion.
Respondent number 5.
5, yes. Page 16, annexure 2.
Yes.
This is not- it's only
Governance
26 January
will
2015.
post of deputy director.
The government the government of Nagaland is to upgrade one post of deputy director on the existing three deputy director.
And so from time to time, and like the team, promote LM long term. Everywhere. So,
So, post has been upgraded from deputy director.
so therefore, you see what they have done, but tell me, whatever may be, how do you take care of without the amendment to Schedule 2A? Joint Director.
Roshni, by this notification, Roshni, can you see the last portion of the last line of the notification?
Hmm.
First paragraph, last line.
Hmm.
The newly upgraded post of joint director who holds the post shall look after craftsmen and training.
Hmm.
This is by way of notification, Roshni. They have not challenged this.
Understood. But the fact that that
The
was,
thing is that they have
that is, you see, page 16, if we look into it,
Roshni.
that is a aspect pertaining to bringing a deputy director to the post of, out of the 3 deputy directors,
Yes.
they have made 1 joint director. Where under craftsman where?
Roshni, the last line of the first paragraph.
The newly upgraded post of joint director who holds the post shall look after the craftsman training wing under the same director.
Yes.
Understood. My question is here. This is a notification. A notification. This is not a case of a amendment to the rules.
So ultimately, the
No,
Yes.
Mr. Munjal, there is a big problem.
Yes.
Your big problem arises with this
Yes.
Schedule 2A.
Now.
Kindly see, wait.
Yes, but
Kindly see the Schedule 2A, joint director. What is his qualification? The post shall be filled up by selection from amongst the confirmed officers mentioned under Rule 3 capital A1B. Meaning thereby, it does not say the other one. Kindly see 3A1B. It does not say 3B1A.
Correct.
1B. It does not say. So without an amendment to this, can by way of an executive instructions which you are referring to, the rules can be amended. This is the biggest problem you have.
Yes. Now, there was disparity in the rules. So,
That is why
yes.
it appears to be a disparity. There appears to be a clear-cut disparity in the rules because on one hand, at Rule 3,
It says.
they mention about a joint director.
No.
Now, Rule 4
No.
categorically mentions who will be there in the service.
No.
Now, the schedule to Rule 4, there are 2 schedules.
No.
One is 1A, 1B. You come under 1B, he comes under 1A. The main problem is in 1B there is no post of alia, whereas in 1A you have only 2 posts. Now, this is very interesting. You may develop, I am not going to dispose it of today itself. You may develop your argument in this. Kindly see 1A.
No.
1A, senior grant, joint director, one is temporary, one is permanent. Only one temporary post.
Yes.
And then is for employment.
It's okay. There's one temporary post. Okay.
Yes.
Now, in the meantime, the posts have increased.
Yes.
As would be apparent,
No.
they have increased it. In that case, the notification of page 16, which you are referring to, is a notification for that employee.
No.
And thereby it could not. Main problem is 2A. Now, can you have to 2A, which categorically mentions what is the promotion, who can be promoted to joint director? It is only from the employment wing.
Yes. Ultimately, there was a challenge in the earlier review.
Then what happened? It was dismissed.
But now, Lordship, the
Correspondent himself challenged, it was dismissed.
So they have to amend this.
yes. Now, ultimately, a proposal has been made Now, the state respondent has already filed an affidavit. It's the marriage date we placed for the.
Mechanism is government of Philippines.
So therefore, he has a good case, Mr. Mujur.
If
There's no way out. Mr. Angami, yesterday I passed that order in that judgment, that motion matter. You take the judgment because the judgment which I have passed may change your entire system for calling for only those persons. I've opened it to everybody.
Yes.
I've mentioned it, I've used 2-3 words out there. Although I had a problem taking into account, you see, the mistake which was committed by the learned coordinate bench with great respect is this. You have an appointment order. In the appointment order, it is mentioned that you are going to be, after 1 year, there will be a suitability test.
Yes.
Now, once you are already terminated, your appointment order goes. So there cannot be a suitability test,
Correct.
isn't it?
Yes.
So therefore, and the petitioner out here is asking for the same order.
Yes.
Now I have to pass the same order because I am bound, isn't it? But I've mentioned that once it has been terminated, which has been upheld by the learned coordinate bench, the posts are vacant.
Yes.
And this post are vacant. This suitability test is test for all.
Yes, now it's for children.
So therefore, you cannot issue a call letter only to them. It may have to think about issuing an advertisement.
It's a wonderful authorization.
Now you have a look because you have to instruct the person concerned because they are initially taking it up on that aspect.
Yes.
Because otherwise, calling for the call letter, means you are going to give an appointment.
Yes. It appears like that.
Because that order, once the termination has been upheld, there is one line at paragraph number 39, one line. The termination cannot be said to be illegal.
Yes. Correct.
So once it is terminated, the posts are vacant.
Correct.
If it is vacant, you have to follow 14 and 16. 14 mentions advertisement.
Yes.
And 16 also.
Yes.
So you know what to do then.
It's a wonderful authorization. I did well.
So, Mr. Mujoi, your problem lies this.
Yes.
He has a good case now.
And my lord, person to see my FME imply just last page.
No, it's okay. Your catch is 2A. 2A, there is no promotion from 3-1B.
Schedule 2A.
That is the main problem.
that matter was brought to the notice of the government. Now, that was been.
So the government should have amended this rule.
Yes, in view of the notification of the they should have, but.
No, not that notification. That notification is different where the government it's a case of high-handedness of the government on that.
There was already a proposal before 15 notification. There was already a proposal.
Now the proposal should be in such a manner that now the posts have increased.
Yes. But
Now,
that has not been done.
once you have increased, one post has to be given here.
Yes,
So there has to be a joint director in that regard.
yes.
Now, that is also not known from the rules.
Very interestingly, the rule 3 says that they can be a joint director. But all this while, the promotion has been stuck with the.
Obviously, it cannot be because you cannot be, the promotion has to be as per Schedule 2A. Schedule 2A has to mention that not only from 3A 1B, it has to be also from 3A 3B 1C 1B. Without that, there cannot be a promotion.
Lordship, we appreciate one thing, Lordship has expressed that we will dispose of this training wing and employment fall under concurrent list as per the constitution. Now, central government has issued a guideline, how to regarding the staffing pattern for the training wing. Now,
Mr. Joe, why should we go into so much? It's a simple issue.
rule 3, schedule 2.
Main problem is Schedule 2A. Not even, you see, you can very well amend. You see, these to 1A, 1B, 1A, 1B, there appears to be a contradiction between Rule 4 and Rule 3. So this contradiction ought to have been taken into consideration at the time when you challenged the rules.
Yes.
But that was not taken.
There
Be
was
that as
something-
it may, I am
it was
bound by the
possible.
division bench
Yes.
judgment. But with this discrepancy,
Oh,
it's
I-
a case of wreath of war warrant to made out. Yes, Mr. Ansel.
And he has to. Have amended, and that probably is waiting for the approval. But you mentioned in certain case, even a draft law can enforce, and that's what I have said in my opinion. If you go by the Supreme Court
I
judgment,
can, where?
1984, we will commodity versus ever higher.
That, Mr. Imsong, that judgment is on a different line. That judgment is on a saying that there was no rules. Now you have a rule.
Yes, we have.
Once you have a rule, unless it is amended, the rule, the drafting has no value.
That is the point. That's the-
There are many judgments on that.
Judgment.
Yes, he has got it.
We are ready to stop.
In fact, that is, Mr. Imsong, that is the issue. What was happening is, in Assam, what we are having, we are already having Assam ministerial court rules of 1987. And one for the district establishment, one for the CGM establishment. Now, these 87 rules, when they were made, there were no posts. Like you don't have a post of computer assistant. You don't have a post of accountant. Because that was not conceived of then. You did not have a post of, you had a post of typist, but you don't have a post of computer typist. These are there. You had a post of, now what has happened? These posts, because of that change which has happened, there is a draft rule. Now, by these draft rules have been made, although the High Court had categorically held that, okay, only follow these for the purpose of promotion. But when the matter came up from before me on the judicial side, I had to say that no, all this which have been done on by the Gauhati High Court on the administrative side is wrong. And that order has been upheld by the division benches. Because draft rules has no value. Draft rules would have if there is nothing.
Wow.
Because when it is a draft rules, you have to also lay it before the legislature also.
Yes.
So therefore, these are things which require to be done. But as of now, here is a case, Mr. Munjal, very difficult question.
My lord, look at the.
I would have said, if it was just the 1A, the schedule 1A or
Yes.
1B, I would have allowed you to make an argument to the effect
Yes.
that the schedule cannot override the act.
Yeah.
But schedule 1A and 1B is connected with rule 4. And more particularly, you don't have there is no manner how you will be promoted to the post of joint director.
Right.
There the problem is like,
Yes.
so we dispose it of.
Yes. The pattern, lots of appreciate. They stuff you pattern for a training.
Because you tomorrow come up with a draft rule or make it a rule also. You cannot, you have to give it retrospective effect to save him.
Cannot have retrospective effect. How
Then-
much that right? For that, I asked the government several times.
Problem lies there, na.
In the present case, that if the draft law is intended to follow the draft law, so that does say, logic behind of this judgment.
Unless the existing rule is amended.
Till the rules remain, you can't help it. Where is the judgment?
Page. Well, I just first, the head law.
Para?
And page.
The rule did not become
94.
inoperative
Just
only
that law.
because of two scales of pay influence or rule validly made even it has becomes unless repealed or replaced by another rule or amended continues to be in. As regards scale of pay, the in terms of the new rules, the criteria prescribed under the old rules were modified. But still the rules were given effect to no promotion to the post of alia could be effected in derogation. This is covered by your judgment. So let us dictate. Heard Mr. Ejo, the learned senior counsel, assisted by Mr. Takatichi, appearing on behalf of the petitioners. Mr. Imting Song, the learned additional advocate general, appears on behalf of the respondent numbers 1 to 4. Mr. M. Mujoy appears on behalf of the respondent. Learned counsel appears on behalf of the respondent number 5. All of you are deputy directors.
Yes.
Yes, leader.
All.
No, not all.
You be
The-
that and close.
You bring director.
Petitioners herein who are working in the
Employment week.
employment wing of the Nagaland Employment and Craftsman Training Services.
Yes.
Bracket class 1 and class 2 and subordinate employment and craftsman training services have approached this court seeking a writ in the nature of quo warranto for setting aside and quashing the promotional order dated 25/2024,
Yes.
whereby the post of the joint director, whereby the respondent number 5 was promoted to the post of joint director. Post. Taking into account that the petitioner is herein, now at the outset it is pertinent to observe that the petitioner number 1 is employed is working in the capacity of a deputy director, whereas the other petitioners are working in the employment wing. Yeah, agote the petitioners herein are so and so working at 13 petitioner. Yeah, herein after referred to as the services. Is working in the deputy director in the employment wing of the services, whereas the other petitioners are working in the employment wing in various other capacities of the services. Taking into account that the petitioners herein have sought for a writ in the writ of quo warranto, this court finds it very pertinent at this stage to take note of a judgment of the Supreme Court, of the Constitution Bench of the Supreme Court, in the case of University of Mysore versus C.D. Govinda Rao and another, reported in 1963, SCC Online, SC 15. The Supreme Court in the said judgment, the Constitution Bench of the Supreme Court in the said judgment, delineated as to when a citizen can claim a writ in the nature of quo warranto. There are two conditions to be fulfilled. First, the citizen must satisfy the court inter alia that office in question is a public office and is held. And the second aspect is that the said public office is held by a usurper without legal authority and necessarily leads to the inquiry as to whether the appointment of the said alleged usurper has been made in accordance with law or not. Paragraph 15 of the said judgment being relevant is reproduced hereinunder. In the backdrop of the above principles, let this court now take note of the brief facts which led to the filing of the present writ petition. Then, conspectus of facts. The services, that is, the Nagaland Employment and Craftsman Training Services bracket class 1 and class 2 and subordinate employment and craftsman training services are being regulated by the Nagaland Employment and Craftsman Training Services and Nagaland Subordinate Employment and Craftsman Training Service Rules 1998. Hereinafter, for short, referred to as the Rules of 1998. From a perusal of the said rules, it is Rule 2 is the definition clause, contains the various definitions. Rule 3 stipulates the constitution of services. The said rule being relevant is reproduced hereinunder. From a perusal of the above quoted rule, it would show that in the services, capital S to capital, in the services, there are two wings. One is the employment wing and the other is the craftsman training wing. 3A, capital A, deals with the employment wing and the various posts included in the employment wing. Whereas 3B relates to the craftsman wing, training wing, and the various posts included within the craftsman training wing. Taking into account the dispute, it is very pertinent to observe that Rule 3A1A stipulates the post of joint director in the employment wing, whereas Rule 3B1A stipulates the post of joint director in the craftsman training wing. Rule 4 refers to the strength of the service. The said rule is relevant for the purpose of the instant dispute, and as such, the same is reproduced hereunder. A perusal of the above quoted rule would show that in terms with subrule A, small a, of Rule 4, the number of posts, permanent as well as temporary, under each wing, that is the employment wing, as well as the craftsman training wing, and the category shall be such as may be determined by the government from time to time. In other words, the number of posts, permanent and temporary, in both the wings have been delegated by the rules upon the government. Subrule B of Rule 4 stipulates that the strength of the service, permanent as well as temporary, together with the scale of pay attached to the rule post, have been shown against each in Schedule 1's small a and 1 small b, provided the number of posts, both permanent as well as temporary, under each wing by the government from time to time. Rule 5 is very relevant for the purpose of the present dispute. Inasmuch as Rule 5 stipulates the method of recruitment, qualification, etc., the said rule is reproduced hereunder. So take your seat. Rule 5 small a categorically mentions that a recruitment to the services has to be made in terms with the manner stipulated in Schedule Roman 2. It could be either by way of direct recruitment or by promotion of persons in the corresponding lower grade. The educational qualifications which are necessary for being promoted, educational qualifications and other conditions which are necessary for recruitment to the post of service shall be specified in Schedule 2.
B.
Huh?
B.
Should not do.
2B.
No. Here it is there.
Yes, the qualifications.
No, I'm going, but as per these, the
Yes.
rules, they don't say so.
But you have provided under the rule 5. Rule 2B.
Taking into account the rules 3, 4, conjointly reading rule 3, 4, and 5, this court finds it relevant to take note of the schedules to the rules of 1998. Schedule 1, capital A, relates to the post, status, scale of pay, number of posts, which would be permanent, temporary, total, in the employment wing of the services. It is pertinent to observe that The post of joint director have been mentioned as serial number 2 and has been shown as a temporary post. Schedule 1 capital B is in respect to the number of posts, status, scale of pay, number of pays, post, permanent and temporary. In the craftsman training wing of the services, notable herein to mention that the said aspect that schedule 1B do not contain the post of a joint director. But 2B is yours. So 2B is there.
Yes, sir. That's the problem. Because under schedule 2B, under the craftsman,
So there can be a joint director.
yes, they can be addressed.
So therefore there is some mistake.
In the schedule 1,
1.
yes.
1B.
Yes, they should have incorporated the joint director as soon as the notification was issued.
They have not done.
They have not done. So that is not my fault. The rule provides under schedule 2B
That there is a post.
Yeah, there is a post. So in the last quarter, Lordship, of November 2025, Lordship, the government was specifically asked whether there was a post of joint director. Lordship, I've read the order.
In the 2B it says that there is a post.
Yes, there is a post. That's how I've been given. And I'm not encouraging upon their post, Lordship. The post has been specifically created for the Lordship, upgraded. We have 3 deputy directors. So that one post of deputy director was upgraded to joint director. And I'm holding the post. This post was held by for my wing.
So as of now, when there was an increase,
Yes,
there was a post of because this 1A, 1B is only in respect to those posts as on 1198.
yes,
This is 28 years before.
yes,
So in the meantime, posts have been created.
yes. Lordship, I was referring to the connections to page 16, the notification. And that post creation, the upgradation was on the proposal of the government. They have not incorporated it or amended that very schedule 1. Lordship. That's what I'm trying to say.
Oh, 2B makes your case.
Lord.
Let me come back. Mr. Joe, I left to dismiss your case.
That's why I was saying this in this paragraph.
I should have, there is no problem for it, there was conflicts. And I show to look after it. I'm asking people when I get it. I'll show that if you do it, I'll share it with the. I was giving a chance, in each other. Like, I'm not really sure this. I want to very good. Just, because you can just, I need to verify about the logic chain.
No, wait, I'll consider. Wait. Though Rule 5 stipulates that the recruitment will be made in terms with Schedule Roman 2. Taking into account that there are two wings, Schedule Roman 2 have been subdivided into Schedule Roman 2 capital A and Schedule Roman 2 capital B. Schedule Roman 2 capital A pertains to the recruitment insofar as the employment wing is concerned. A perusal of Schedule Roman 2A shows various posts, including the post of Joint Director. The said post of Joint Director, as per the eligibility and conditions stipulated for promotion, is to be made from the confirmed officers mentioned in Rule 3, capital A, 1B, small b, provided the officer had completed qualifying and continuous service of 3 years in that grade on the first day of the year on merit cum seniority basis. Schedule 2 Roman 2B is in respect to the craftsman training wing. Wherein also there is a post of Joint Director to be filled up by way of promotion from amongst the confirmed officers as mentioned under Rule 3 capital B, small b, provided the officers have completed qualifying and continuous service of 3 years in that grade on the first day of the year on merit cum seniority basis. In the backdrop of the above, it is the case of the petitioners in the present writ petition that in terms with Schedule 1 capital B of the rules of 1998, the post of the Deputy Director for Training Wing is the last promotional avenue. However, in contravention of the rules of 1998, as well as the judgment and order dated 29/2023, passed in WPC number 261/2021. The respondent authorities, by the impugned communication notification dated 28/2024, had given officiating promotion to the private respondent number 5 to the post of Joint Director. It is also alleged in the writ petition that the respondent number 5, who was granted an officiating promotion, have been regularized on the recommendation of the DPC by the order dated 25/2024, the petitioners allege that the impugned regularization order dated 25/2024 is illegal, as the respondent number 5 has been transposed from the craftsman training wing to the employment wing. The record reveals that pursuant to the filing of the present writ petition, the learned coordinate bench of this court by an order dated 3/12/2024 issued notice but did not pass any interim directions except observing that a promotion of the respondent number 5 to the post of joint director would be subject to the outcome of the writ petition. The record reveals that the respondent number, that the state respondents have filed their affidavit in opposition, wherein it is mentioned that there is a proposal to amend the rules of 1998 inasmuch as not permitting a person from the training wing, craftsman training wing, to the post of director was discriminatory. In that regard, a draft amending rules have been prepared in the year 2026, whereby the defect in the Schedule 2 is sought to be rectified. It is also mentioned that the steps have been taken by the state respondents in line with the proposed draft amended rules of 2026. Further to that, it is mentioned that the judgment and order dated 29/2023 in passed in WPC number 261/2021 no longer hold in respect to the promotion of the respondent number 5. The rules of 1998, as well as the draft rules so prepared in the year 2026, have been enclosed as annexures to the affidavit in opposition filed by the state respondents. The respondent number 5 have filed an affidavit in opposition. Thereby justifying the promotion of the respondent number 5 to the post of joint director. Emphasis was laid on Rule 3, Rule 4, Rule 5, and Schedule Roman 2B. It was also mentioned that the government, in exercise of the powers under Rule 4 small a of the rules of 1998, had created the post of joint director by the notification dated 16/1/2015 by upgrading the post of the deputy director. In that regard, reference was made to the notification dated 16/1/2025, 16/1, 2015, which have been enclosed as Annexure 2 to the affidavit in opposition. In addition to that, the proposal for upgradation of the post of the deputy director to the post of deputy director, one post of deputy director to the post of joint director, which led to the issuance of the communication dated 16/1/2015, have also been enclosed. The record further reveals that the petitioner had filed an affidavit in opposition, affidavit in reply to both the affidavit in opposition filed by the state respondents as well as the private respondent number 5. In the affidavit in reply filed by the petitioner to the affidavit in opposition filed by the respondent numbers 1 to 4, it was stated that the rules of 1998, unless it is amended in accordance with law, still holds the field. The draft rules, which are of the year 2026, is yet to be given effect to. Moreover, it is mentioned that the respondent number 5 was appointed in the year 2024, whereas the draft rules are of the year 2026 and is yet to see the light of the day. This is what you have said. In addition to that, an affidavit in reply have also been filed by the petitioner to the affidavit in opposition filed by the respondent's private respondent, wherein it is mentioned that Schedule 1A shows the total strength of the manpower and post creation with scale of pay up to the post of director in the employment wing, while Schedule 1B shows the total strength of the manpower and post creation with scale of pay up to the post of deputy director in the craftsman training wing. Schedule 2A, by Rule 5, deals with the employment wing for promotion to the officers in the employment wing, which can go up to the post of director, and whereas Schedule 2B, by Rule 5, deals with craftsman training wing officer who can go up to the post of deputy director, and the same have already been decided in WPC number 261/2021 by judgment and order dated 29/2023. Full stop. In addition to that, it is also para.
Main justify that there is no post-creation for training wings. I have the next RTI. I'm just waiting for the chance to explain that. There's no post-creation for training wing, even deputy director. That is the RTI.
In addition to that, it is also mentioned that though a provision has been made for the training wing under Schedule 2B for the post of joint director, no such post creation has been done till date. And as such, the upgraded post was held from the employment wing to look after the craftsmen and training wing since 2015. In that regard, reference was also made to the RTI reply, which have been enclosed to the Annexure B to the affidavit in opposition, affidavit in reply.
The order by another finance shown is of 2015 is from the employment. RTI reply is very clear. Till today, for the training wing, only of principle. There is no post creation for deputy director, joint director.
RTI reply dated 17th April 2026, wherein it was provided, wherein information was provided.
Post creation and upgradation till date. Till 2026.
The post creation and upgraded till date status in respect to the employment wing as well as the training wing.
Yes. That will answer everything.
Gusto.
My friend keep referring to monitoring 16 January 2015. That is clearly stated in the reply, page 27, last employment wing column 2 below close to 3. One post of upgraded wide notification number sensor that is 16 January 15 to look after craftsman training wing from employment wing to look after the training wing because they have no deputy director post. They have no joint director post. So how can they say that they have a post of joint director and deputy director? Why not? This is from the Joint Secretary Government of Nagaland. Reply. And worship will see. That's why in the first bit I was mentioning, in order to create most of deputy director and joint director, sitting pattern, sitting capacity is required. In Nagaland, we have 600 trainees, 641. So therefore, there cannot be any post creation for deputy director given for that. Lordship, I have a training pattern which provides. So therefore, Nagaland government is not foolish for that. Though provision has been made in the service rule, see there's no seat depending on the seating capacity. They have not even created for deputy director and joint director money. So simple as that. I have the norms for stuffing pattern for the direct effect my law. Lordship may kindly see.
It is further relevant to take note of an order passed by this court.
Paragraph 26 of the Supreme Court order, my lord. 66, 65, clearly said that there is no joint director post for the training wing, even 2023. Page 78, paragraph 65. The division bench has held that there is no post of joint director for training.
Whereby the order dated 21/11/2025, whereby instructions were sought for by way of an affidavit. Whereby the state was directed to file an affidavit. It is in pursuance to that the affidavit was filed by the state respondents. On 29th of April 2026, the reference to which have been made herein above. There is no reply to the affidavit in opposition, affidavit in reply submitted by the petitioner, and more particularly in reply to the RTI reply dated 7/4/2026. 17/4/2026. In the backdrop of the above pleadings, this court have heard the learned counsels appearing on behalf of the parties. Mr. Ejo, the learned counsel, senior counsel appearing on behalf of the petitioner, submitted that for the purpose of upgrading the post of the deputy director to the post of the joint director, there has to be at least principal is the deputy director. Huh? Well,
Director is higher than this.
Huh?
Deputy directors are higher. For the post of deputy director, there has to be 2,000 to 4,000 trainings. In
Well,
Nagaland, we have 640.
under the schedule. Principal worship schedule 2D.
No. You see why I'm saying so? Deputy director is the principal senior grade. Policy, it's rule 3. Rule 3, you see.
Well, senior grade.
So deputy director is the principal senior grade.
Senior grade.
So, and junior grade is assistant director is principal.
Though it's not mentioned.
No, it's okay.
Yes.
It's mentioned. Now kindly come to their affidavit in reply. If you see, 4 posts were created of principal. In the training wing.
Last page.
27, page 27 worship.
Yes, training wing.
It's training.
Ah.
So admittedly, the director posts, there are only 2 under the employment wing.
1. Where do you get it to?
In the page 27, the RTA responsible.
Where? 2
As-
posts. The one has been abolished, no? Kindly see. Deputy director to joint director, 2 posts.
2 posts. But going back by
1 post of deputy director upgraded by notification dated so and so, and the post of deputy director abolished. See? So once it is upgraded, it is abolished. 1 post upgraded by notification to which you are referring to look in after the craftsmen and training.
Training win, that is the point.
If this is done from their part,
Yes.
so therefore there is no post of deputy director.
Training win. No.
Now, if there is no post of deputy director, how is petitioner number one the deputy director?
That is the issue.
Tell me,
My lord.
how are you? The petitioner number one is the deputy director.
We're from training and employment wing.
Understood, but you see, there are two joint directors. Kindly come to page, the last part of your affidavit.
Lordship will come and schedule 1A, 3 posts of duplicate for us.
Schedule,
Schedule 1A for us, for the employment wing, there are 3 duplicates. 1 permanent, 2 temporary. Total 3.
3.
Yes,
Now, this has happened then.
yes, in terms of.
Now, therefore, you see, this is, now you kindly see the joint director to additional director. There is again joint director to additional director. Now, additional director is not a post which is there in the schedule.
No, there is issue.
Not there.
For joint to
Provision
director.
is there, but process will be created. Provision is there, but process will be created depending on the requirements of the.
So
staff.
now where is the post of deputy director? In the training wing.
No. Lordship, training wing,
Where's the post?
in terms of the rules,
Huh?
Lordship, in terms of.
Not the rules. You see, we are concerned this, you see, the rules are made in the year 1998. At that time, what was this? It's a different aspect. But here, if we see the employment wing, here for post creation and upgraded till date. So where is the post of deputy director now?
My lord, that is what I'm saying. If your lordship see the staffing pattern, I have provided a book. Depending on the seating capacity, was has been created. So today, lordship, may I see the guideline, the training, I have provided a book. Lordship, may kindly come to the fact. How staffing pattern has been provided by central government. For the training, particularly for the training, and we have already flagged now.
Page,
Already flagged now. Staffing pattern, norms for staffing pattern at Directorate of States, Union Territory for implementation of craftsman training scheme. Lordship will see additional director, the students for the training wing, student, there should be 5,000 to 10,000 seats for additional posts. Training, so and so. Now come to 2. Joint director, issued 1 post of joint director should have 3,000 to 7,000 seats. Now deputy director 3. 1 post for 2,000 to 4,000 seats in Nagaland. The prescribed seating capacity is 1,292. And the present seating capacity, the actual present students are only 641. So for these reasons, I was trying to explain from before. For this reason, posts are not created as per the RTI reply given by the Joint Secretary to the government of Nagaland. So why, and this is followed all over India, my lord. Why it was going to be argued the earlier case before DB, I have highlighted all this. This pattern has been followed all over India. That's what from the beginning I'm saying. This falls under the concurrent list. Standard government, state government can make the guide rules. So we go by the central guideline. Therefore, posts are not created for even deputy director and joint director for the training wing because the seating capacities, trainees are not there at all.
Mr. Mujoy, what is your client's name?
Lordship,
Alongside
name,
Your client's name?
H alongside. H alongside.
And who is this M. Liwang Konek?
he is also from training and employment women. I have given a chart. How he was appointed, how he was. He is also from my week.
No, Lordship.
So he is now the joint director.
He retired my God. I have lordship in the chart sheet, in the chart, I have given at the bottom. How he was appointed, how he retired.
Where?
Lordship, I have provided one chart. In the morning, when we start. Yes, my lord. Last page. So that lordship will find convenient. The appointment of Alan Kumar. He entered as He. MD1, first page man. He was on employment wing. He retired as joint director. Then against him, a person, engineer Gauhati, who was on training wing, came in. So we challenged, we filed a war warrant. He resigned and he left. Again, the resulting vacancy of Gauhati, this gentleman, aforesaid was found. So we have filed this petition. Because it's a clear case of transposition, man. Usurping the office and power of joint director, which is meant, which arose from the training wing, man. Implement.
Another aspect, my resolution is saying that there is no post of deputy director. There is no post of deputy director.
No, I'm saying, but the RTA reply says so.
Not lordship. The RTA is in conflict with the
That I cannot answer.
page 17 of my affidavit.
Page
17, lecture 3. The type is at page 18. How the government is replying to the RTI lordship without verification of the documents? Page 17 of my affidavit lordship. The type is at page 18 lordship. To the director and employment lordship is from the government. Creation of one post of deputy director must come from government training wing under the director of employment and government training. This is dated 24 October 1986.
This is before the rules came in.
Yes.
Then
Before
I
I
am directed to refer to the above cited subject and convey the approval of the governor of Nagaland to the creation of one post of deputy director plus one government training wing under the director of employment and government training in the scale of so and so plus interline compensatory allowances and rate of so and so basic to the maximum so and so and all other allowances as part of this book from 99 in Nagaland to be divided away. The expenditure is deliverable in the head of council so and so. There is a plan expenditure. Now, this section issues with the governments of the finance governor by number so and so dated 29/8/1989. Now, coming back to the next to page 19, lordship. This one, the PNR. Now, the type copies at page 20. The matter has been examined by the PNR department and we agreed to the proposal for regularization to the upgradation post of senior grade principal ITI in the scale of 10,000 so. So this is the deputy director post,
page
page 20.
better like examine and we agree the proposal for elimination of application of the posted grade month scale of the- Now, the senior grade upgradation of post of senior grade ITI Kohima
Yes.
to what post?
To senior principal, yes, the deputy director post,
So this is senior grade principal is deputy director.
yes.
So this
The
so
RK is in conflict.
no, RTI
RK
says
says that only up to principal.
no, RTI says furnishing information on the RTI regarding draft employment. You may collect regarding your letter dated and on the above subject, I am directed to furnish the following information as desired by you in so and so. Post creation and upgraded till date. Joint director to additional director, so the joint director post from the employment
From
wing.
my way, from Lima, complete from my way.
No, your post
Yes.
of joint director
Yes.
have been upgraded to additional director. Now, deputy director to joint director, there is an upgradation. One post of deputy director upgraded to so and so. This is done in 1998. Isn't it? Kindly see page 27 of your affidavit in reply.
Yes, my lord.
So one post of joint director of the employment wing has now become the post of additional director.
Yes.
Okay. Now one post of deputy director in the employment wing have been upgraded to the post of
Right.
joint director.
Yes.
And the deputy director post is abolished. Okay. So 1 and 2. So 1 is this. Then one post of upgraded by notification dated so and so to look after the craftsman and training wing.
That is.
So this is from the employment wing, it has gone there. Now, here there is a creation of 4 posts. So therefore, if we look into this particular document, 1 post upgraded by notification post of deputy director to the joint directors in the pay band of so and so, and allowance as so and under the demand of so and so, under the directorate or employment of so and promotes so the senior most deputy director to the newly upgraded post. The newly upgraded post of the joint director to hold the office shall look after the craftsman training wing under the same directorate.
Look after.
Look after. The issue is so and so, and the approval of the upgradation committee and all the approval of the cabinet and so and so. Now, you, at your time, do you have a joint director? There's no joint director.
We have one director, one additional director, one joint director.
You have. Obviously, then that is his.
They already finished.
An additional director has come from, you see, the additional director has come from this. Additional director has come from joint director from yours. So you have an additional director post, although that is not mandated in the rules. Then you have a joint director post, which was the only director post there. You had an only one joint director post in the 1998, if we go as per 1A.
Yes.
That too a temporary post.
Aspiration.
So therefore, this deputy director being upgraded, it is not mentioned from where it has gone, except this RTI.
It is mentioned. Lord, you must see the affidavit filed by my friend, page 15, 16. Lordship, I can ask me again. May I read it? Governor of Nagaland is pleased to upgrade 1 post of deputy director out of existing 3 posts of deputy director to that of joint director in pay so and so per month, and all allowances as are admissible from time to time under the directorate of craftsmen and training in Nagaland, Kohima, and promote Alan Kumar. He is also from employment wing. Yes, I have given the chart. And you see, Lordship, so Alan Kumar is from employment wing. I have given the chart. And now, Lordship, if you see the schedule 1A, capital A, there are 3 posts of deputy director for training wing, employment wing.
Where you have given the chart?
Lordship,
As regards LM Longkumar?
Lordship, in the morning, I have given the chart.
No, I have it.
Last page. How Alan Kumar was appointed and from which week, then cleared it out.
So he has gone from there.
Yes, very much. This is what we call. So therefore, there is no way. That's why I'm saying it's transposition, which is not allowed by Supreme Court. I have a small judgment to show on that transposition right now.
But how do you take care of Rule 4A?
Rule 4A, my lord, as lordship have one true. Rule 4A is for the employment wing.
No. Rule 4A. The number of posts permanent as well as temporary under each wing and category shall be such as may be determined by the government from time to time.
Correct.
So therefore, Schedule 1A and 1B will be absolutely within the jurisdiction of the
Government.
So the government now thinks this to be from this wing. How can you touch it? Therefore, when he mentioned it, he has referred to in his affidavit, he had mentioned Rule 4A. This is absolutely the jurisdiction. Because once the posts are being created, it is absolutely the discretion of the government.
My lord, discretions of the government. But they have to keep in mind that there is an existing rules. And it will go by the rules. It will go by the
Therefore, the rule says.
So now therefore.
So therefore, on the you see, kindly see what is 1B. On the commencement of these rules, the strength of the sum is permanent as well as temporary, together with the scale of pay attached to it have been shown in so and so, as on the date on which it has come. Provided the number of posts, both permanent areas shall vary. Temporary under each wing by from time to time. So the government may keep on changing.
Yes.
So therefore, how do you take care of this? If the government tomorrow says, just for example, the upgradation which is being made from the post of deputy director to joint director, there's an upgradation made. There's no quarrel with that proposition,
Yes.
and that is also apparent from
I
your
have,
one post of joint director which you had. That has been already made at the post of additional director. Although the rules do not say anything.
as far as the training wing is concerned, when the training wing challenged the legality of the rules in 2023, the DP had matter until such time, pursuant paragraph 65, page 78.
Yes.
Mary, reverting back to the present case, the challenge in the present case is the constitutional validity of the Schedule 1A, Schedule 1E, Schedule 2A, Serial number 1 on the ground that the Indian schedules of the civil rules 1988 gives undue advantage to officers of the employment with by prescribing the avenues for promotion after the entry point after the post of director. Whereas for the officers of craftsman training wing, it only provides for entry up to the point of joint director, though no post of joint director has been created as on date.
Where?
As on date.
Which paragraph?
Page 78, page 78, just running page.
Page 78.
Paragraph 68, 65.
What
Paragraph-
is the challenge you have influenced?
Here,
In the alternative reason, I have also paid for you. Okay, we find that the service will provide reasonable classification in this way, and we have these things so and so. I take note of the position I belong to the craftsman training wing and the response number 53 belong to the employment wing. While the employment wing is in charge of administration, West area is charge of demand. You are referring to which paragraph?
paragraph 65, running page 78. Page 65. Paragraph 65 of the judgment. During that time, the training wing, the private respondent, he is the petition number 2. They challenge the legality.
But Mr. Jot, the question before the learned division bench was on the aspect pertaining to the virus of the rules.
Yes, rule schedule 1. Yeah,
Not on the question of whether there has been an exercise of power under Rule 4A or 4B.
The undue advantage is there.
on that-
Therefore, he has the locus to come and approach this court. You have the locus.
Our only condition in before today is till 2023, there is no as one adjustment. After referring to after collecting all the reports. Now, the court held that after viewing all the report, there is no there's no post creation for the post joint director in respect of training wing. And then lordship after that, now as I have referred to my affidavit reply, RTI. The RTI reply was very clear that there is no post creation for the post of deputy director, joint director for training wing. So in what way this court will
No,
respond?
here it is being said on the basis of Schedule 1B.
My lord,
And
schedule
it-
1B is different issue, my lord.
No, here he say, whereas for the officers of so and so, it only provides for entry into joint director through not, though no post of joint has been created as on date,
Yeah,
and there is
as
no
on
mention of the IMEA which derives the iman. In alternative, petitioners have also prayed for a direction on so and so by incorporating the provision of joint director additional and also prescribe the avenues of promotion to the post of director. This is what he is being asking for.
Yes.
This is what is being the case. which have been set out. Now, where is the finding? Therefore, we are persuaded to the schedule of so and so are unconstitutional and not persuaded. So here, what is being the challenge? The challenge was as regards the rule, Schedule 1A, Schedule 2B, and 2A are unconstitutional. Now, therefore, the question is the court was looking into the virus of the act as to whether the rules are constitutional or not. The constitutionality of a rule depends on many aspects. One, if it is in violation of the fundamental rights. Two, if it is ultra vires, the statute. And these rules are made under 309, so it is violation of the constitution. So these are the parameters on which these rules are to be challenged. Now, these may not be what which has been given. It may not apply to this aspect. But my question is, how do you take care of 4A and 4B?
Well, as to meet that requirement, the RTA reply says so, because there is official that has come through RTA reply.
No, therefore, Mr. Joe, if the power has been delegated to the state.
Correct, I agree with that.
If the power has been delegated to the state for varying this, they can keep on changing this. 1A, 1B will keep on change because of the fact that therefore you have to conjointly read 3, 4, and 5. In 1998, there was only one temporary post of joint director. Now, you are having 3 posts of joint directors.
Obviously, because of lordship, because of the strand, now the requirement, like I said, the lordship has seen this proof pattern. Now in Nagaland, the requirement for the post of deputy director is 1,292, whereas in the present case, as on today, only 640 trainees. Therefore, government is wisdom has decided that you should not create post for deputy director. It will be a waste of government exchequer. Practical is right. Practical is my job. So
then why did the government appoint him and made him a joint director?
That is why I'm saying it is absolutely illegal. It's a transposition. So therefore, we have to for.
But is he looking? No, my question is, Mr. Joe, whether he is looking after the affairs of the employment wing.
No. Training wing.
So he's only looking for the affairs of the training wing.
Lordship will see when there is no post for the training wing, as it is not required, as I said, it is said, as per RTA. When there is no requirement, absolutely promotion to the post is illegal. When there is no requirement for the post of deputy director, come join director. When there is no requirement, how can they promote to the post join director, which is meant for the employment wing? Employment wing.
No, you have to tell me how many posts have been created for joint director at your place, in your wing?
That as per the rules,
No, rule is one temporary. You are already having 2.
No.
One additional.
Additional different.
Additional has been from joint director, it has been upgraded.
That's correct.
So that is apparently 2. Now, if he works out there, in the government thinks that he needs it only for the training wing. How are you saying that post has been taken from you? Your post is how much?
So if 16 notification is very clear. He shall take care of the craftsman wing. So that is meant for me.
And
Craftsman, lordship the language.
that notification also is created from the employment wing. 16 notification is from employment wing. That's my argument. If the 16 notification of 2015 was created for training wing, I surrender. Knowing that they
But whatever may be, you have in this petition challenged what?
appoint promotion of the private respondent.
So promotion on the ground of a warrant of.
Yes.
But the government presumes that he is the joint director. There is a post of joint director, and it has been upgraded and given it to him.
I didn't just come from another department and occupy the post.
Source may kindly see to government
All
affiliate.
the while I've been in the department.
My lord,
And sixteen is very clear.
my lordship will see.
They are supposed to take care of
Government
department.
affiliate, if lordship read paragraph 5 of government affiliate, how he was promoted, look at this government affiliate, the official stand of the government. Paragraph 5 of government affiliate. This is how they defended the appointment, which is not tenable in eye of law. Paragraph 5 of government affiliate. Paragraph 5 of government affiliate. Government, the stand of the government is that, no, we are going to amend the rules in 2026. So in view of that, in anticipation of the 2026 rule, we are giving a promotion in 2024. How it is possible? Because this, they cannot change the affiliate.
No, it's okay. I'm not on that. I'm not on that aspect. Now, as of now, you see out here, interestingly, kindly come to page 43 of that affidavit,
Of which affiliate?
the government affidavit. We get what is the strength,
Which
page 43.
government affiliate? It's a government affiliate. My lord, in my only last page is 25 government affiliate.
What?
Government affiliate, last page is page 25 only.
He has not given you the draft rules.
No, only page 25. No,
No.
that page 25.
You don't have the draft rules?
So this is the view, the draft of. This is the only page 25.
I give it to him. Page 42.
I have only 25.
No, it's okay. Kindly give it to him. Anybody has the entire thing?
The draft rule proceedings.
No, the schedule to the draft rules.
No,
I think that must be the.
no, existing.
It's okay. No, I'm just trying to find out one thing. Have you got it?
Yes, sir.
I'll give it to him.
Oh, page 14. no?
Page 42. I'm reading these rules. Affidavit in opposition filed on 9th of April 2026, which
By
was
the
filed
state.
on 29th.
By the state,
Huh?
by the state.
By the state.
Also, I don't have that.
You also don't have it. Anyway, have a look at Mr. Joe. How is it possible you file it like this? Mr. Imsong, I'm going to impose a cost upon you. In Gauhati, I impose 25,000 in such types of misdemeanor. I will impose out here 10,000 upon you on the council. Give him this file. Will impose a cost upon you, 10,000. See that, page 42. Now, interestingly,
Yes,
this
page
particular document
Yes.
shows how they are proposing. The schedule. So there they are having one post of director, okay? One post of joint director for each of the wings.
My lord.
You see this?
Yes, my lord.
So one post,
Right.
meaning thereby, how can there be three posts now? Oh, one is the director, there's an additional director is not there.
Additional that goes to my lord.
Huh?
My lord is there.
Additional director is given for both.
Both.
Now, what do you have about the director, the joint director?
Director,
One post.
one. my lord.
So when they are making these rules in 2026, their idea is to have one joint director, one director, additional director for each wing, and one post for director common for both. This is what they are contemplating of having in 2026. Now, my question is, the creation of posts is absolutely within the domain of the state. If that is so, if one post is reduced from you, my only question is, if one post is reduced from you, you have a case. If one post is reduced from you by the government, it's an action for the government.
My lord, in my humble submission. As I have put out, these guidelines were already, I have done that.
Understood?
Now, worship is, when even if they propose for new rules, that has been in line with the guidelines.
I'm not on that, new rules. My concept, I have shown you these rules only for what is the government's intention in 2026. Although it has been done or not, it's a different thing. Now the question of one post, this post which is being given to him is absolutely only for the training. Rightly or wrongly, it has been given to him only for the training. By creation of a post by the government under 4A. So can you say that is a case of quo warranto?
Yes. Because as far as the RTA depends.
Unless you challenge the creation of the post.
There's no post creation as for RTA. There's no post creation, madam. And then 2015 not finished for us for employment, if you worship have that.
No, but
That's not
you
employment.
already have a joint director.
No, whatever it may be, 2015 not finished for us. Post creation for employment will number one. And number two, the RTA replies that not required for post creation is not there. My lord, when there's no post creation, how can a person be promoted from training wing? My lord, 2015 not which have read again and again, that is for us. If lordship has read. Why is it for? Because government keep it in mind that there is no requirement because it's
But
students are not.
then that post to us. You see, this post which is being used from here, from the year to the creation of an upgraded post. Was this 2015 notification by which it was created and upgraded to that only for that particular person? Or was it for the department itself? Because if it is for that particular person, obviously, once he retires, then a post reverts back as the deputy director.
Upgrading, yes. Excellent.
It comes back. But here it is not so. It has been upgraded. And thereby allowing that person only to look into the craftsman wing.
That post was created for employment, look after that. training.
Maybe that is the government doing it.
That government has done that.
Rightly or wrongly, the government has done that. That is not the subject matter of challenge here.
My lord, I'll just take lordship's attention.
Anyways, let us.
You know.
You have a lunch. For lunch.
What?
Huh?
My lord.
Very page 2가 보시죠. page 5가 지금 시세 다운 보시도 돼요.
유명한 사람들이 렉처 했고 네. 이거 네. 보라나가 알리나세.
아기 있어요. 내가 뭐
Not regular.
Check, cross check. This is satisfying. But you smell it.
여기는 요
Regular mobile.
You check cross.
Very good.
The manner, that's why I know. I wish followers this is very thing.
I think I'm not saying
Now, you should know.
Mr. Ajo, the learned counsel appearing on behalf of senior counsel appearing on behalf of the petition submitted that a perusal of rule 3, 4, 5, as well as schedule 1A and schedule 1B would show that there has been no creation of the post of joint director in the craftsman training wing. And as such, the very appointment of the petition respondent number 5 to the post of joint director from the craftsman training wing is absolutely illegal, for which this court is illegal and unauthorized, for which this court may issue the writ in the nature of quo warranto. Elaborating his submissions, the learned senior counsel drew the attention of this court to schedule 1A and submitted that the post of the joint director is clearly shown, whereas a perusal of schedule 1B would show that there is no post of joint director. The highest promotional post to the post in schedule 1B is the post of deputy director. The learned senior counsel further referred to Annexure B to the affidavit in reply filed by the petitioners against the affidavit in opposition filed by the respondent number 5, which is the reply dated 17/4/2026, wherein it would show that there has been no creation of post of post of joint director in the craftsman training wing. Rather, the post of the deputy director was upgraded to joint director by the notification dated 16/1/2015 from the employment wing of the services. He therefore submitted that this is a fit case for issuance of a writ in the nature of quo warranto. Additionally, the learned senior counsel submitted that the stand which have been taken by the respondent authorities is an absurd stand on the basis of a draft rules which is yet to be given effect to. In that regard, the learned counsel had referred to the judgment of the Supreme Court in the case of Union of India versus Ramakrishnan, reported in 2005, 8 SCC 394, and specifically referred to paragraph number 26. 26, na? 26 and 28.
Yes.
Which stipulates that a rule made under Article 309 of the Constitution continues to hold the field unless the said rules are not repealed or modified. The modification in respect to those rules made under modification or repeal of those rules made under 309 of the Constitution the modification of the said rules made under 309 of the Constitution has to be done in the same manner in which the rules under 309 have been made. Mr. Im Song, the learned counsel appearing on behalf, additional advocate general appearing on behalf of the petitioner, a respondent state submitted that the rules of 1998 are discriminatory in nature, and it is under such circumstances steps have been taken for modifying the rules by the draft amendment rules of the year 2026. He further submitted that keeping in mind the draft amended rules of 2026, the petitioner have been granted the appointment, the respondent number 5 have been promoted to the post of the respondent of the joint director. Too slow. At this stage, this court finds it very pertinent to take note of the reply which have been made by Mr. A. Joe, the learned senior counsel, appearing on behalf of the petitioner. Petitioners, wherein he has mentioned that Mr. M. Mujoy, the learned counsel who appears on behalf of the respondent number 5, per contra, submitted that a reading of Rule 3, 4, and 5 conjointly would show that the post of joint director is there in the craftsman training wing of the services. Schedule 1A and Schedule 1B were made at the time when the rules came into effect in the year 1998. He submitted that the power has been given to the state government to vary or change the Schedule 1A and Schedule 1B. And under such circumstances, in terms of Rule 4 of the rules of 1998, and as such, the state government had in exercise of the powers under Rule 4 have upgraded the post of the deputy director to the post of joint director by the notification dated 16/1/2015. The learned counsel further submitted that this is not a case wherein a writ in the nature of quo warranto can be issued without a challenge to the action on the part of the respondent authorities in creating a post, in upgrading the post of the deputy director of the booking of the employment wing to the post of the joint director of the craftsman training wing being created, that too without a challenge to the said notification dated 16/1/2015. The learned counsel for the respondent number 5 further submitted that once the post had been created by the communication dated by the notification dated 16/1/2015, there is no mention that the said post again has been reverted back to the post of deputy director. And the person who was asked to man the post of joint director by the notification dated 16/1/2015 was specifically asked only to look into the craftsman training wing and not to the employment wing. He therefore submitted that without a challenge to this creation, the question of the respondent number 5 being an usurper upon being appointed to the post of joint director does not arise, and as such, the instant writ petition is misconceived. He further submitted next. Mr. Joe submit Mr. H.O., the learned senior counsel, had also submitted that the fact that there was no creation of the post of joint director in the craftsman training wing is not only apparent from the reply to the minutes, reply to the RTI on 17/4/2026, but also is apparent from a reading of paragraph number 65 of the judgment of the learned division bench of this court dated 29/2023, passed in WPC number 261/2021. Mr. M. Mujoy, replying to the submission made by the learned senior counsel for the petitioner, that there was no creation of the post, that insofar as the observations made in the judgment of the learned division bench of this court in the order dated dated 29/2023 in WPC number 261/2021 submitted, that the said judgment would not be applicable, and the observations if so made can at best be an obiter, inasmuch as the issue involved before the learned division bench in WPC number 261/2021 was as to whether the rules of 1998, and more particularly Schedule 1B, was ultra-virus the Constitution, having not taken into consideration the case of the persons employed in the craftsman training wing. The learned counsel further submitted that if any such observations is made, such observations being an obiter, the same would not apply as a precedent upon this court which would be binding for the decision in the present case. In that regard, he has referred to the judgment of what? Judgment of the 7 judges bench of the Supreme Court in the case of Bengal Immunity Co. Limited versus State of Bihar, reported in AIR 1955 SC 661, as well as the judgment in the case of B. Samarao versus Union Territory of Pondicherry, reported in AIR 1967 SC 1480. This would have heard the learned counsel's analysis and determination. Anything?
This one,
Yes.
should may kindly see, private respondents affidavit, page 4.
Of government.
Regarding the post creation of private respondent 5. Paragraph 4, page 4. The issue is whether post was created to promote the private respondent 5 or not. That is the issue.
Hmm.
Page 4 of the affidavit filed by private respondent 5.
Yes.
Page 4, paragraph subpara E.
Hmm.
Thereafter, by notification number so and so, that is 61 to 15, the government notified the upgradation of one post of deputy director to joint director. The above notification specifically indicates that the upgraded post of joint director shall look after the craftsman and training wing under the same director. However, relevant part, however, for the reason best known to the government, the senior post deputy director from employment wing was promoted to the upgraded joint director post of the training wing. Now, NHL 2 mile. Who is this gentleman promoted now? Now, the governor of Nagaland, this is dated, notification dated 16 January 15. The governor of Nagaland is pleased to upgrade one post to the post of deputy director out of existing 3 posts of deputy director to that of joint director in pay so and so month per month, and all other allowances that are admissible from time to time under the director of employment from and training wing Nagaland, and promote Alan Long Kumar, the senior most director, to the newly upgraded post joint director. Now, this post was given to Alan. Now coming to my note, thereafter, this post was the post held by private school is never created. Now, worship the seat, he was promoted again the post of Liwan Kwanya. Liwan Kwanya post was from employment with this Mahamad. Worship, I kindly come to the impugn promotion order, page 89, in my repetition manual. There is a misinterpretation of the upgradation manual. Page 89. Worship, come to serial number training wing. Serial number 1. Engineer H. Alongside. Again, the resultant, this is relevant, my lord. Again, the resultant retirement vacancy of Engineer Gauhati. So Engineer Gauhati's post was held by the employment wing. So therefore, there's no, it is not that post was created to accommodate private sector 5. No. Private sector 5 has been promoted to the post of employment wing. This is why apparently from record, the impugn order shows that he was promoted again the resultant vacancy of Engineer Gauhati, which the post is meant for employment wing. So that interpretation is required. That is the whole contention. Yes, my lord. Now, Engineer Gauhati was holding the post of joint director, which was meant for training, but we find the challenge warrant, so he resigned. He resigned, and now therefore, my lord,
Who resigned?
Gauhati, this engineer Gauhati resigned and he left. I have stated in my affidavit.
He resigned to contest election. He resigned to contest election.
Whether it to contest election was, why after filing warrant of petition, hardly he resigned and he left because he knew the consequence. Because
But that court had not decided that. But Mr. Joe, the problem is not that. The problem is how the government have treated. You have not challenged that action.
well, but that I cannot, because that was what
If you cannot challenge the government's action of creation of the post or allowing him to manage. You have not challenged this.
My lord,
You have not challenged a person who is from the government has used this appointment of the joint director out there to be used for the purpose of looking into a craftsman wing.
my lord, the was created nomination 16 January 50 was created and given to align with from employment wing. I have no grievance against that.
No, Mr. Joe, kindly see.
And
This is a case of a creation of a post. There might be an illegality in creation of a post or doing something to that effect. But the fact that for issuance of a quo warranto, it's difficult because the government has put this thing under the control of the thing, rightly or wrongly. I'm not on that. But you ought to have challenged that action also. How on earth did you allow this post to be used for that? Therefore, you should have asked for a declaration. The government could not have used it. Without that, how can I issue a quo warranto in view of the Rule 4?
Lord, I
think
I should challenge the
no,
nomination.
Mr. Joe. All other submissions will be taken up by the division bench.
Lord,
Either.
My lord, my humble submission is
No more submissions. I've recorded the submissions.
I cannot challenge the nomination because that is in my favor, this nomination. Was created and given to align with from employment wing, so I cannot challenge. Was created and given to align with from employment, so I cannot challenge.
No, you need not challenge that notification. You are to challenge the fact that how the government permitted it.
Absolutely, one post was created.
You see, these posts will keep on varying by the state. That is Rule 4. Anyways,
My lord,
this court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. At the outset, this court have duly taken note of the scope of the present proceedings, which is as to whether this court is required to exercise the powers of a writ in the nature of quo warranto. The two preconditions for exercise of the writ of quo warranto are that the office in question is a public office and the person who is appointed to the said public office is a usurper having no authority to hold that office. This court, in the foregoing paragraphs of the instant judgment, have dealt in detail the provisions of the rule 2, 3, 4, and 5 read with Schedule 1A, 1B, Schedule 1, 2A, and 2B. From a perusal of Rule 3, it is apparent that there is a post of joint director in the craftsman training wing. Rule 4 makes it very clear Rule 4B, small b, makes it very clear that Schedule 1A and Schedule 1B, where the strength of the service permanent and temporary, together with the scale of pay attached to the post, as on the date on which the rules of 1998 came into force. It further stipulates that the number of posts, both permanent and temporary, can be varied under each wing by the government from time to time. This aspect is further explicit from the reading of Rule 4A, which empowers the government to determine the number of posts, permanent as well as temporary, under each wing and category from time to time. Therefore, the power which had been conferred upon the government under Rule 4 is a delegated power whereby not only the number of posts which are permanent as well as temporary could be varied, but a category also can be determined by the government from time to time. Therefore, reading Rule 4, the entire emphasis on Schedule 1A and 1B to decide the present dispute would not be proper. Inasmuch as stated above, Schedule 1A and 1B is the number of posts as on 1/1/1998. There's no quarrel with the facts that as on 1/1/1998, there was no post of joint director in the craftsman trainings wing, which is in Schedule 1B. One is 95, na? You see, what is this, page 58? Yes. No, of these rules. One is 1/1/98 has been shown, the other has been shown as 1/1/95. On top, Mr. Joe, on top, just on top. Here.
My lord, 1195.
The other is 1/1/98.
You are right, what should be right? One in 90, one in.
There's no quarrel with the proposition that as on the date on which the rules were promulgated, rules of 1998 were promulgated, there was no post of joint director created in the craftsman training wing. And obviously, the same could not therefore be included within the ambit of Schedule 1B. However, insofar as the employment wing is concerned, there was a post of not only the director, but also a post of joint director created, though temporary. Though permanent and temporary, respectively. And therefore, there is the inclusion of the post of director and joint director in Schedule 1A. The said aspect is further clear from a reading of the said aspect that there is a post of joint director also conceptualized in the rules of 1998 in the craftsman training wing is further clear from Schedule Roman 2A and Schedule Roman 2B. Inasmuch as in Schedule Roman 2A, the post of the director as well as the joint director have been categorically mentioned. Whereas in Schedule Roman 2B, the post of the joint director is mentioned. In other words, a reading of the rules, conjoined reading of the rules 3, 4, 5, as well as the schedules aforementioned would show that the post of the joint director has been conceptualized in the craftsman training wing. Though at that point of time when the rules were promulgated, the post of the joint director was not created, which would be apparent from Schedule 1B. This aspect is further apparent from the affidavit in opposition filed by the state, inasmuch as the rules of 1998 has been said to be discriminatory inasmuch as there is no promotional aspect from the craftsman training wing to the post of director. And by the draft amending rules of 2026, what has been supposed to be done is to give an opportunity from the craftsman training wing to the post of director, a promotional consideration from the craftsman training wing to the post of director. In the backdrop of the above analysis, the question therefore arises as to whether the promotion of the petitioner, respondent number 5, to the post of joint director can be said that the respondent number 6, 5 is an usurper to the said post. In this regard, this court finds it very pertinent to take note of the submission of Mr. A. Joe, the learned senior counsel, who submitted that the post of the joint director, which was created by upgrading the post of deputy director, was from the employment wing. And the person who was promoted by the notification dated 16/1/2015 was the senior most deputy director belonging to the employment wing. And therefore, he submitted that the post of the joint director was all along within the employment wing of the services. This would have duly taken note of the said notification dated 16/1/2015. And a perusal of the said notification reveals, amongst others, is that the post of the joint director, deputy director, was upgraded to the post of joint director. And the person was specifically asked to man the craftsman training wing and not the employment wing. The manner in which the government have chosen to use the post of the joint director by allowing a person from the employment wing to man a post, to man the craftsman training wing, appears to be done in consonance of the powers reserved upon the government under Rule 4A and 4B of the Rules of 1998. In other words, the government have interchangeably used the person from the employment wing to carry out functions as a joint director of a craftsman training wing. The question under such circumstances is as to whether the respondent number 5, under such circumstances, being allowed to officiate and being regularized to the post of the joint director, which was created, and to look after the craftsman training wing, can be said to be a usurper. In the opinion of this court, the same cannot be, unless the government have clearly identified the functions of the joint director, specifically to man the services, joint director of the employment services, employment wing, to only exercise the powers over the employment wing and not the craftsman training wing. Whether the government is right in doing so is a question which could have been challenged by the petitioners. But be that as it may, this is not a case by which the respondent number 5 can be said to be a usurper to the post where he have been permitted to officiate and regularized. Let this court further take into account the judgment take note of the submissions so made by Mr. A. Joe, the learned senior counsel, that the creation of post aspect have been already dealt with by the learned division bench of this court in the judgment dated so and so in WPC number 261/2023. And the same observations so made would be binding upon this court. It may not be out of place herein to mention that perusal of the judgment dated so and so, passed in WPC number so and so, would show that the virus of the rules of 1998 were challenged on the ground that it is ultra virus, the Constitution of India. The learned division bench of this court was only called upon to answer as to whether the rules in question, rules of 1998, were ultra virus, the Constitution, and not to make any observation as regards the creation of the post or not. Any observations so made in the opinion of this court would not only come within the ambit of an obiter, but also within the mischief of the rule of sub silentio. And as such, the same would not be binding upon this court. Consequently, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Mr. Imsong, I have to impose a cost, na?
My lord, forgive
Huh?
Worship, this is a remote, but I will not a responsibility. But this will get a lesson from you also. You will say, vice versa, you know. I don't really think it's fine.
This is not done, Mr. Joe. Therefore, I could not refer to that. Na? In my judgment, I could not refer to that because otherwise Mr. Joe tomorrow will say in the division bench that look here, this was a document which was not given and therefore he has referred to it. And I was prejudiced at the time of hearing.
Yes.
For admission, item numbers 2 to 6.
Landowner is, but you are otherwise famous for appearing or opposing land ownership. These matters pertain to what? You have filed affidavits. These are regulation under what provision? Both. Why both are connected together? One is against vacant post and the other is creating of supernumerary post. All of you have completed 30 years. Means there are many petitioners. Now what do you want? Huh?
Item number 2 and 6 I have already filed, and 4 and 5 I will send for vacant. Then item number 3 I will get a receipt instruction.
What is item number 3?
3 Lordship.
This is pertaining to?
Oh, that's no.
The question arises if he has completed 30 years, you have to consider. Provided he is in the scale of pay. 30. So if he is not 30, his repetition has to be dismissed. Or should we wait till you become 30? Or is it something like that? Let the mangoes ripe, then we'll pluck it off.
Your worship of item number 2 and 6 sometime to find out.
You want to file. She wants to file and you also want to.
Decline, Your Lordship.
The counsels appearing on behalf of the parties submits that the pleadings are not complete. Considering the fact that some of the petitioners have already retired, superannuated,
Yes, Your Lordship.
after rendering service for more than 30 years, and some are awaiting their regularization. It is the opinion of this court that the matter requires an urgent disposal. However, the pleadings being not complete, an additional opportunity is required to be given. Accordingly, list this matter again on 25th of June 2026. In the meantime, the parties shall exchange their pleadings.
For admission, item number 7.
His Lordship, Lordship, here I'm here to receive instructions, so can you directly explain?
You have got the money?
Yes, we have paid, yes, Your Lordship.
You have paid the areas?
Yes, everything, Your Lordship, even that, she has been granted the University of the.
And you have got it.
Yes, she has got it.
Now you have been terminated.
No, not terminated, notice for termination has been issued.
Notice for termination.
Yes.
Where?
Page 68.
8?
68.
In pursuance to so and so, so and so, so and so, I, one month hereby issued for termination in respect of so and so, who is in here and there. Why have you terminated?
Your Lordship, as per the.
Has there been a stay?
Yes.
There's
there
an
is a
order.
mistake, yes.
Notice is hereby issued for termination. There's a stay?
Yes, yes.
So you're working?
Yes, Your Lordship.
You're getting your salary?
Yes.
Up to date?
Yes, Your Lordship, yes.
No, it's okay. Then we will have it after. When are you going to retire? We'll see from here, no? We'll get it here.
She's not holding essential post. So
44.
It's illegal. so-
You're 44. Let us have it after 16 years. Then why are you doing all these things? 1 month's notice. Have you terminated anybody else?
No. The entities in the department are Was appointed similarly like the petitioner, but only the petitioner has been given the notice to proceed.
I think, madam, we are not only going to, we will ask this person, deputy commissioner, he is, this action is contemptuous.
No, because.
Yes, because of the fact that you are doing it, you are making the reference, kindly see. In pursuance to the PNR's letter dated so-and-so, in so-and-so, state of Nagaland versus so-and-so, and so-and-so dated so-and-so, so-and-so, 1 month notice is given. Are you referring to the judgment?
Yes, yes.
This is, Vince, you are trying to interfere with the cause of justice. Let's initiate criminal contempt against him. We do one thing, we initiate tomorrow, let this matter be took place tomorrow. I'm sitting in division bench, I will initiate criminal contempt against this officer. No, madam, this is a very serious thing. Because what you should have done, if you had anything else you could have done, but the moment you are referring this is very serious. Take your instruction, we'll have it on Friday. I think you asked him to withdraw this. Because this is very serious. You take any other grounds, do whatever ground. But mentioning this, here this petitioner came up before this court on the ground that look here, I should be given the minimum scale of pay. Matter, the single judge allowed it, went to division bench, it allowed. The Supreme Court on the first day said, comply with the order. And then it was withdrawn, saying that we are, and thereupon making it a basis for issuance of a notice of termination. You tell him that this is not there, otherwise next week we are initiating criminal contempt against him. Because this clearly comes within the ambit of criminal contempt, interference with the cause of justice. We'll have it on Friday. Ask them to withdraw this. Huh? Interim is extended, they are going to withdraw it. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so, the learned additional AG appears on behalf of the respondents. The present petition has been filed challenging the order, notice of termination dated 31/3/2026 on the ground that the petitioner having filed the writ petition on the ground that on account of the petitioner filing the writ petition and orders being passed thereby directing payment of the minimum scale of pay to the petitioner, vindictive actions have been taken by the respondent authorities to issue the impugned notice for termination dated 31/3/2026. This could have also perused the order dated 31/3, the impugned order date notice dated 31/3/2026, and the very reference made to the proceedings which led to passing of orders thereby granting minimum scale of pay to the petitioner appears to be one of the reasons. The said reason, in the opinion of this court, constitutes an interference with the course of justice. Ms. V. Sukroy, the learned additional advocate general, submits that she would obtain instructions as to whether the respondents would like to pursue with the said notice of termination. List the matter on Friday. Interim orders passed earlier shall continue till the next day.
For admission, item number 8.
Yes, tell me.
I have received this letter from the department.
For what?
Yes, it's under consideration and I have tried to submit certain documents. The reference and the replacement order. It's not a matter.
Need to submit a initial appointment letter dated on submitted by the concerned division. And only after you found the people Sure. Madam, we do one thing. We close the writ petition. on the basis of this quoting it and give him a liberty if in the circumstance it is not carried out, and thereby direct him to place the necessary materials before the authority concerned. Lekho. Heard? You got your file?
Yes, my lord.
Show me.
Yesterday, my lord, one of the friends who was watching the live telecast online, after the court, he's not a lawyer. He told me that told me that this the judge should not come down and assert you physically.
But I extended the interim order in that case.
I am deeply obliged.
You may not be serious, but I have put that order very clearly
My lord.
that you are not serious.
My lord,
You have taken the matter in a trivial manner
my
and
lord,
therefore not to list the matter till you give an undertaking before the registry that you will be serious in doing our matters.
the wrong file was wrong.
What?
The wrong file was wrong.
You didn't, you said that I didn't bring the file. You never said that the wrong file was brought.
Yes, instead of putting the wrong, how to was wrong. They are of the
You,
same
you
time, so
had,
there was a
you had
confusion.
8 matters that day. Yesterday you had around 7, 8 matters.
Yes, my lord.
You could have very well picked up one file out there and you picked up that file thinking that this court would allow the writ petition without even asking you. But the question arose because you did not, you have enclosed out there and mentioned it as an annexure 4, a notification dated 5/3/2018, but you have not enclosed it.
My lord.
When I asked you which page it is, then you had the problem. You never said that I have forgot to bring the file.
My lord. I told my lord, when asked, I told her that I had forgotten. In fact, the next case was also mine yesterday. I put item 6 and 7, they were consecutive, and similar cases brought you. So I was actually reducing the item 7 petition. Because immediately after item 6, item 7 was to be called. It was also mine.
You don't have juniors.
I have item 2.
Eh?
They are also trying their best
Huh?
they are also trying their best to assist
Where is your junior?
in chamber lordship.
Oh, heard Mr. Sanjayanga, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the Ms. S. Sang appears on behalf of the respondents. The petitioner herein has approached this court being aggrieved by the inaction on the part of the respondent authorities in considering the case of the petitioner in terms with the office memorandum dated 5/3/2025 in non-consideration of the case of the petitioner as per the office memorandum dated 5/3/2025, as well as not regularizing the services of the petitioner in terms with the office memorandum dated 17/3/2015. The case of the petitioner herein is that the petitioner was appointed on 21/7/1991 as Workshore's labor in the office of the subdivisional officer, PWD Pomching subdivision, and was issued a work charge identity card being code number MON/0052. The petitioner is supposed to retire in the month of July 2026 upon completion of 35 years. Under such circumstances, as the petitioner was otherwise eligible, you have got the scale of pay.
No, my lord.
Okay.
As per the
30.
the mental and demanding scale of pay.
As such, on the Iman, on completion of, he's supposed to retire in the month of July 2026 on completion of 35 years, which is the mandate as per the Nagaland Public Employment. What is that? which says na age is up till 35.
Yes, yes.
What is the name?
Yes, Nagaland Retirement for Public Employment Act 2009.
2009. Pust- It is seen that though the petitioner have not been granted the scale of pay all this while, that a notification was issued, that an office memorandum was issued on 5/3/2025, whereby all workers and casual employees in all departments whose names have been duly verified by the district level verification committee and registered in the PIMS receiving fixed pay shall be granted scale of pay as per the revision of pay 2015 with effect from 1/4/2025. Under such circumstances, as the petitioner was on a fixed pay, the petitioner would be entitled to the scale of pay with effect from 1/4/2025 by the office memorandum dated 5/3/2025. The respondent authorities not only did not consider the entitlement of the petitioner in terms with the office memorandum dated 5/3/2025, but also by virtue of the office memorandum dated 5/3/2025 and having rendered more than 30 years of service. The petitioner was entitled to be regularized in terms with the office memorandum dated 17/3/2015. It is under such circumstances the petitioner submitted a representation on 13/11/2025, and the same having not been considered, the petitioner has approached this court. The record reveals that pursuant to the filing of the present petition on 22/4/2026, a notice was issued by this court on 27/4/2026. In pursuance thereto, the Engineer-in-Chief, NPWD, Nagaland Kohima, have issued a communication to the petitioner on 14/5/2026 to the effect that the petitioner's case is under consideration and the petitioner has been asked to submit certain documents. It is the opinion of this court that the contents of the said communication be brought on record. The said communication is kept on record and marked with the letter X. The contents of the said communication is also relevant to be reproduced and relevant, and as such, the same is reproduced hereunder. From the perusal of the contents of the document, which have been kept on record, from the perusal of the document, which have been quoted here in above, it is apparent that the respondent authorities are now taking up the matter of the petitioner for regularization. And have asked the petitioner to submit certain documents. Mr. Santiago, the counsel submits that the petitioner is taking steps to submit those documents. Are you or not?
Yes, my lord.
Yes. Considering the above, it is the opinion of this court that keeping the instant proceedings pending would serve no purpose. Accordingly, the instant petition stands disposed of with the following observations and directions. The respondent authorities herein are directed to consider the case of the petitioner in terms with the office memorandum dated 17/3/2015, which aspect is also apparent from the document issued by the Engineer-in-Chief NPWD dated 14/5/2026, which is reproduced herein above. Number 2, the petitioner is granted the liberty to again approach this court if, in a circumstance, the respondent authorities do not reject the claim of the petitioner. Huh?
For admission, item number 15.
Just-
For admission, item number 15.
Dear my lord, I received the contract with the county this morning in federal court, and they can be provided 3 weeks to file my plan. It is like a session.
No, why you are referring to, it is Nagaland Retirement for Public Employment Act 1991.
Yes, my lord, because the school is a government funded school.
No. It is not 2009. You just said 2009. It is 1991. Yeah, I got it. It was like 1991, Nagaland. Retirement from Public Employment Act 1991. As amended in the year 2009.
Well,
So you are challenging the rules.
no, I'm not challenging the rules.
You have retired.
Yes, because of the amendment in the rules also.
But you have not challenged the rules.
I have tinkered, no, Lordship, I'm not challenging this act. I am saying that the rules have not been amended by the school authorities, my lord, by the managing authorities headed by the commandant of second NFP as per the 2009 act. Because earlier we were to serve till 35 years. Now they have reduced it to 25 years, and based on that, I feel terminated.
Where is the rule, relevant rule?
My lord, Annex 4,
Page,
page 19. The relevant part is of page 20 also.
page
Page 20.
20. Where?
Number 3, rule number 4, retirement age. Retirement age decreased from 35 years to 25 years. And based on this lordship. I'm going to review.
Affidavit filed. Where is state?
We found this one about the.
What do you say?
Lordship is a purely private school. Private school. So we are telling, our condition is a private school doesn't come under the Article 12. So the premises of the petitioner must be committed through
So you are covered by the judgment of St. Mary's.
Yeah, we are basing on them. St. Mary and Lady College, Army Welfare School, there are so many rulings are there.
Lordship, I believe, Lordship, my case will be covered by the, instead of St. Mary's, by, and the Mukta Satguru's case, Lordship.
It's a private school, obviously,
Yeah.
insofar as
Practical
it
components
relates
was-
to some fees and all, public is affected, obviously.
Even the Nagaland retirement from public, living in 1991, it is not applicable because that section 2, clause 1, public will include that clearly defined.
The
So scarce you have to
My lord, whether the state exercises control over the,
No, let us assume that the state exercises some control over it. Then also it cannot be, because these are purely private schools.
Lordship,
Giving a granting aid, they don't come within the ambit of public employment.
Lordship,
Retirement age is absolutely within the domain of the state, of the particular authority. That is, so we dismiss.
Lordship, no, Lordship. Out of 21 teaching and non-teaching staffs, out of 30, Lordship, 21 are employees of the home department, my lord. And their salary is entirely funded by the state government. If there is any eventual renovation, then the
Anyways, you survive
Road start.
today, only on the basis that the government affidavit is not on record.
my lord.
Hmm. When did they file the rule affidavit? Oh, you want to file reply?
My lord.
Absolutely no. I haven't seen the order. It is seen that my order of 23-3, that is a very bad thing. I keep on coming to Kohima so soon. It is seen that though the petitioner have sought for various opportunities to file the affidavit in reply, but the affidavit of the filer is yet to be brought on record.
No, my lord. No. I believe the affidavit in opposition was filed only today, Lordship.
Worship,
That never so
the worship page, in some other pages, also we have a paragraph. And the recipient also has some time to reply to my affidavit, but going to the report, that affidavit of motion was not filed.
But
So
where is it?
first-
It has been filed today.
Yes, we follow it today.
It has been submitted that the affidavit in opposition, the objections to the affidavit in oppositions have already been cleared. And the registry have accepted the affidavit in opposition filed by the respondents. First of, Mr. Sentenga, the learned counsel appearing on behalf of the respondents. A petitioner submits that 2 weeks' time may be granted to file the reply. This matter again on 15th of June 2026. In the meantime, the affidavit in reply be filed.
For admission, item number 16.
Why did before the division bench it was taken?
Lordship, this matter will be closed. Because initially, I filed an application before election, challenging the election of the present petitioner here. And then they have filed an objection with regard to the mentionability of the election petition, that it is not in accordance with rules. However, ignoring that, the election tribunal has decided to proceed with the case. Against that, the approach this honorable court. During the pendency of this present petition, we wanted to withdraw the election petition because admittedly it was not filed under the prescribed rules. But then they have objected for withdrawal of that because no liberty should be given.
No?
No liberty should be given after withdrawal. Because we wanted to withdraw the petition with liberty to file afresh. They objected to that. Against that, we approached the division bench, which has closed that case. So we can withdraw the case and we don't want any liberty. It is an election matter and the duration of the election is only for 3 years. 2 years already gone during this period. And if I withdraw and then file a fresh petition, Lordship is very aware the procedure involved in an election petition. So
This is an election to where?
municipal town council. Town council. Under a municipal act. Municipal election.
It is under municipal body.
Yes. No, it's town council, a small township. And it is objection with regard to the candidature of the present petitioner that she doesn't belong to us. Indigenous inhabitant of Nagaland. So
Now you are willing to withdraw the election petition
yes,
Without
now they are
liberty.
before the tribunal,
without liberty.
without any liberty.
And you are challenging this matter, why?
Lordship, they filed the election petition after the prescribed period of litigation. Lordship, Section 45 of the Act says that the election petition has to be filed within 15 days from the date of publication. Lordship. So they filed after the period of 15 days. So we challenge that in Lordship. Now what happens that earlier also they have prayed for withdrawal of this case, withdrawal of the election petition. However, without withdrawing, they filed an application for liberty to file afresh as well as for condonation of the delay, Your Lordship. Now, condonation of delay in election petition is not permissible, Your Lordship. Yes, Your Lordship. 15 days is 15 days, Your Lordship.
Show me where is it? They filed. Let us save Mr. Citizen the trouble of going to the municipal council to withdraw. Let me only set aside that. Where is that order? You have passed an order, na? Challenging an order dated 29/7. Where is that?
Page 74 is the order by which cognizance was taken. That is page 74.
Election petition was prepared before the election tribunal municipal year by the Imam who have been elected as Aloki member UB form so and so. That's what's the obtaining teaching us to place the Imam. Before the election petition was heard, the Petitioner filed an addendum to the election petition on demand stating the membership of so and so contested and won the recently contested demand. Also requiring event to keep independence with the people thought in teams it fit that all measures should be given an opportunity to submit a reply. Then the next order,
Page 82. By this order, my
page
82. By this order, my preliminary objection to reject.
has filed so and so challenging the election of so and so in the recently completed demand. Raised preliminary objections contending that the petition was not filed in the prescribed form and manner and the Nagaland Municipal Act was not properly applied in as much a petitioner failed to comply with the mandatory provisions of the Nagaland Municipal Act, specifically regarding.
Operative portion is towards the end.
Huh?
Page 83, towards the end. Last two paragraphs.
Is directed to Tribunal finds that while the procedural compliance is essential, it is well settled within that procedural technicality. The issue raised by the regarding the eligibility of the respondent to contest seriously litigation. Preliminary objection raised by the respondents are hereby dismissed. Against this, you have
We
come.
raised preliminary objection and then that was dismissed.
So let us see the Nagaland Municipal Act. Where is it? Now, if it is Nagaland Municipal, give me the constitution. Part 9 says, when did you file? When was the election results?
Election result declared on 29 of June 2024.
Huh?
29 of June 2024.
29/1/2024. When did you file?
29
26.
June.
6.
Yes.
Okay, when did you file?
15 of July.
15/7/2024.
It should have been filed on or before 14th.
On or before 14th.
Yeah.
Now.
You can see that even the election petition also, the manner in which they have filed motion. No affidavit, no verification. It is just a letter, your lordship. Let's take it.
Where is the power to challenge? Filing the election petition where? Which is the section, madam?
Section 45A.
45A. Yeah, 45A, small a. Okay, hello. Let us dismiss this petition. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. C.T. Jamid, the learned senior counsel, assisted by so-and-so who appears on behalf of the respondent number
2.
2.
Yes.
Who is 3 and 4?
No, 3 in the nominee.
Nominee.
Okay, 2. Mr. So-and-so appears on behalf of the respondent number 1 and 4. 1 and 4. At the outset, Mr. M.T. Imsong, the learned counsel, learned additional advocate general, submits that in an election, that the instant proceedings is a offshoot of an election petition. And under such circumstances, the state of Nagaland or the election tribunal ought not to have been made a party. He therefore submits that the respondent number 1 and 4 be struck off. Taking into account the above, taking into account that in an election petition, it is only taking into account the well-settled principle of law that in an election petition, it is only the petitioner, it is only the return candidate, all or other candidates who can be made parties, and not the state of Nagaland or the election tribunal. This court strikes out the respondent number 1 and 4. The present proceedings arises out of two orders passed by the election tribunal in election petition case number 2/2024. The said orders are the orders dated 29/7/2024 as well as the order dated 18/3/2025. By the order dated 29/7/2024, the Learned Election Tribunal, without the Learned Election Tribunal, had issued notice upon the petitioner herein, who was the return candidate. The order dated 18/3/2025 is based upon an application, is on account of an order passed on an application filed by the petitioner for dismissing the election petition on the ground that the said election petition was filed beyond the period of limitation. First, taking into account the above, this court finds the following finds relevant to take note of the brief facts which led to the filing of the instant proceedings. The petitioner herein contested from
The town council. From ward number 4. That seat was reserved for women candidates.
by the notification number, by the notification dated 29/4/2024, the schedule for the elections to the municipal and town councils were published. The petitioner, as well as the respondent number 2 in the instant proceedings, both contested the said elections. The petitioner was declared the winner after the nomination of the petitioner was found to be valid during the scrutiny. The declaration of the petition that the petitioner was the return candidate was made on 29/6/2024, and the certificate of election was issued to her on 29/6/2024. The respondent number 2 thereupon filed an election petition on 15/7/2024, questioning the election of the petitioner on the ground of improper acceptance of the nomination paper. The question which arises in the instant proceedings is as to whether the challenge, whether the election petition could have been filed on 15/7/2024 to question the election of the petitioner who was issued the certificate of completion of election on 29/6/2024. In this regard, this court finds it very pertinent to take note of Article 243 ZZ of the Constitution, which stipulates a bar to interference by the court in electoral matters. The said article being relevant is reproduced hereunder. A perusal of Clause B of Article 243 ZZ shows that no election to any municipality shall be called in question except by way of an election petition presented to such authority and in such manner as is provided for by under any law made by the legislature of the state. First, the Nagaland Municipal Act 2023 is the law made by the state of Nagaland, by the state legislature of Nagaland. Section 45 deals with of the Nagaland Act of Municipal Act of 2023, for short the Act of 2023, deals with disputes regarding elections. Subclause A of Section 45 being relevant is reproduced hereunder. A perusal of the above quoted provision would show that the election petition has to be filed, that an election of a member of the municipal council or town council can only be questioned by way of an election petition, and such election petition has to be presented before the election tribunal appointed by the government in that behalf within 15 days from the date of publication of the result of election under Section 44. First, in the instant case, it is seen that the election petition was filed on 15/7/2024, which is delayed by 2 days. 1 day has to be removed. 30, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. 15 is 16 days. 15 days, by 14. Ought to have been filed on or before 14/7/2024. Was it a Sunday? Not Sunday, are you sure? Then you get 1 day. Fifteen 7/2024.
14 July. 14 July is a Sunday.
Sunday. So then it is one time. It's on time. You can't file it on Sunday. You can't file it on Sunday.
You should file on or before 14 July.
On or before. So 14th, that is the last day. Limitation Act categorically mentions that the last day, that is also as per the General Clauses Act 1897, which categorically says if it is the last day, it is on a holiday, the next day will come in. But this is within the time. Thereafter they withdraw, that's a their lookout.
That's okay.
Not only that, your lordship, even the election petition will also.
I'm not on that. That I'm not going to look into. Here he has only on. Ought to have filed it on or before 14th of July 2024. It is relevant to take note of that 14th of July 2024 is a Sunday. Sure, na?
Yes. I have verified. If it is wrong, then the system itself will be.
Sunday. And as such, Filing the election petition could not have been filed on 14/7/2024. The election petition having been filed on 15/7/2024, the same would have to be construed to be within time. Under such circumstances, this court does not find the order dated 18/3/2025 passed by the election tribunal to be ultra-virus, the provisions of section 45A of the Act of 2023, or the provisions of Article 243 ZZ of the Constitution.
Lordship, apart from the delay, they have also raised other grounds of lordship.
That has not been considered, no, yeah.
Even the petition is there, even in the
Madam, first and foremost, I am not taken up. When you file this, the CPC applies.
yes,
When the CPC applies, you should have filed an Order 7 Rule 11. You have not filed that. You could not have just filed an application like that. Can't help you with that.
even the
No, all these things will be taken up later on. Nah? Election tribunal cases has to be completed within 6 months. This will be taken at the final there. So therefore, if you see the judgment of NP Punuswamy as well as Mohinder Singh Gill, interference at the initial stage does not arise. Considering the above, this court does not find any ground in to interfere with the order dated 18/3/2025. However, for reasons aforementioned, considering the above, this court does not find any considering the above, this court does not considering the above, this court does not find any reasons for interfering with the order dated 18/3/2025, for which the writ petition stands dismissed. Before parting with the record, this court, however, observes and directs that the instant judgment so passed is only in respect to dealing with the question of limitation in filing of the election petition. And this court have not dealt with any other objections so raised by the petitioner in the said application, in any other objections so filed. And any other objections which has to be decided by the election tribunal as and when issues are framed by the election tribunal. Interim orders, if any, stands repeated. See, you had a case, Mr. Jamil. And luckily it came to my mind while dictating.
For admission, item number 18.
Hello. None appears on behalf of the party. Oh, you are appearing? Yes, what is it? Okay. I'm going to file a reply. Mr. Afongsok Gupte, the Learning Council, appearing on behalf of the petitioner, submits that the petitioner would like to file a reply to the affidavit in opposition filed by respondent number 1 to 7. Considering the above, the instant with petitions, considering the above, the matter stands adjourned to be listed again on 25th of June 2026. In the meantime, the reply be filed by the petitioner.
For admission, item numbers 19 and 20.
May I please, Your Lordship?
Yes.
Your Lordship, I may be allowed another 2 weeks, Your Lordship, to file my affidavit, Your Lordship.
The whole matter.
Yes, Your Lordship.
So,
Your Lordship, on the last occasion only I received instruction, and meantime, Your Lord, due to my personal difficulties, I could not able to completely complete it, Your Lordship. But it's almost ready for vetting, Your Lordship. So if this Lordship can kindly grant me another 2 weeks, then I will file it, Your Lordship.
with cost,
No, Your Lordship, may be gracious. I had some personal difficulties, Your Lordship. So
Ms. Livika, the Learned State Council submits that on account of her personal difficulties, the affidavit could not be filed and assures the court that the affidavit will be filed within 2 weeks.
2 weeks, Your Lordship.
List this matter again on 22nd of June 2026. In the meantime, the affidavit in opposition be filed in both the marriage petitions
Yes, Your Lordship.
without fail.
Yes, Your Lordship. Much obliged, Your Lordship.
For admission, item number 21.
Yes, what is this? Hmm?
Last time when the letter was listed before my Lord Justice Krishna Nair,
Hmm.
he suggested, so it is not affected in the order that certificate that we obtained from the district administration indicating that I was independent.
What is your case?
And
Application for appointment on compassionate grounds on here, but the same was not considered. Hence, the petitioner filed with petition. No difference has been made between a married daughter and unmarried daughter in paragraph. You are married?
yes, my Lord.
You are not getting it. Married daughter, what will you get it? How will you get it?
Lordship,
Have you filed affidavit?
yes,
Okay. You have filed reply?
yes, I want to file reply. Today is only the first.
Okay.
written number.
Okay, Mr. Santiago, the counsel appearing on behalf of the petitioner submits that the affidavit in opposition has been filed on 6th of May 2026.
On 12th, I received on 12th.
You got it on 12th, that's a different thing. It was filed on 6th. He therefore submits that an opportunity may be granted to the petitioner to file a reply. List this matter again on 26th of June 2026. In the meantime, reply be filed on behalf of the petitioner.
For admission, item number 22.
Doshi Jamil. Yes.
Lordship, instructions to appear on behalf of this number 1, 2, and 3. I'll be filing my power.
Your name? In the matter, there is a stay.
Yes, basically.
Till next status quo is maintained as regards the work order. Work order has happened what?
It is 1626. It's not.
None appears on behalf of the petitioner on call. The respondents. You appear for respondent number?
1, 2, 3.
You have earlier also sought for time. Mr. So-and-so 6 for appearing on behalf of the respondents. Numbers 1, 2, and 3, 6 for some time for filing the affidavit in opposition. List this matter again on 25th of June 2026. In the meantime, the affidavit in opposition be filed.
For orders, item number 9.
May I please your lordship? My
Yes,
lord, I'm appearing for respondent number 2 and 3, my lord. We received pair-wise comments, my lord. I may be further allowed 2 weeks' time to file our affidavit, lordship.
what is the matter about?
My lord, the petitioner claimed exemption under 1026 of the Income Tax Act, my lord. Huge cash deposit was made, my lord, at Delhi branch of my lord, the bank of the petitioner, my lord. And my lord, after filing this writ petition, they have also preferred an appeal, my lord, before the appellate authority, which is still pending as on date, lordship. So we'll bring everything on record, lordship. I am praying for only 2 weeks' time, lordship.
You have filed an appeal?
On that, I have no idea. I'll have to get instructions from my director.
Yes, lordship, this writ petition was filed, my lord, immediately after 3 days, my lord. Appeal was preferred, my lord. And in appellate proceeding also, my lord, notice was issued on 16/2/2016, my lord. 26, lordship. So, my lord, they have not responded to the appellate authority also, my lord. Appeal is still pending, my lord. We'll get everything on record, lordship.
Okay. Okay, Mr. Suman Setia, the learned standing counsel of the Income Tax Department submits. But why there should be an interim order then?
Lordship, because that they have not mentioned that they have already preferred an appeal, my lord. That was suppressed, lordship.
The suppression.
Lordship.
You get your instructions out there. Mr. Suman Setia, the learned standing counsel of the Income Tax Department submits that the instant writ petition should be dismissed on the ground of suppression of material facts, taking into account that in pursuance to the order passed by the assessing authority,
Lordship.
an appeal been filed before the appellate authority.
My lord.
And this aspect have not been highlighted, mentioned in the writ petition. The learned standing counsel have also stated that while the appeal is pending, this court may not like to exercise the extraordinary jurisdiction under Article 2 to 6 of the Constitution. Mr. Sentieng, the counsel or the petitioner submits that he would obtain instructions in that regard. List this matter again. Next week you are having it.
Lordship, in that the income tax department may can't be permitted to grant available.
Not necessary. When he says out there, he will only produce that here. You just file whatever may be out there. We'll take it up on file. We'll have it on 2nd of June. This is the matter of 2nd of June 2026.
Lordship.
Earlier shall continue till the next date.
Lordship, the appeal was preferred, my lord, immediately after filing of this petition. My lord, this petition was filed, my lord, on 17th of May 2024, and appeal was preferred on 21st of May 24. And thereafter, lordship, notice was issued on 27/5/24, my lord, after filing of the appeal, my lord.
I'll seek instructions on that.
Writ petition filed on?
My lord, 17/5/2024, my lord.
And appeal filed on?
21/5/2024, lordship.
24.
And my lord, notice was issued on, my lord, 27/5/2024, after filing of the appeal, my lord.
In the instant writ petition?
Lordship.
27/5.
My lord.
Okay. 24. I'll just put it out there. Has submitted that the petitioner, though had approached this court by filing the writ petition on 17/5/2024, but immediately thereafter had also filed an appeal against the assessment order on 21/5/2024. The learned counsel, standing counsel for the Income Tax Department submitted that even assuming the petitioner ought to have on 27/5/2024, when the instant writ petition was taken up, disclose that an appeal had been filed in that regard against the impugned order. First, Mr. Sentienga, the learned counsel, submits that he would obtain instructions in this regard. List this matter on so and so. Interim on 2/6/2026. Interim order passed earlier shall continue till then.
I'm obliged, Lordship.
Keep your best.
For orders, item number 10.
One of the PO dated 7/5/2026. If existing steps.
Service complete. On behalf of the respondent. Notice issued upon the respondent number 2 by AR postal receipt have been received in ZR, however, service is still awaited. Service is awaited?
Lordship, the law is still in the light by this law report.
You have done it?
Yes.
Have you filed the affidavit
Lordship, I didn't file.
of paper publication?
Yes.
Where is it?
Final on first of May.
It is not here. Mr. Fonseca update the council appearing on behalf of the petitioner submits that in pursuance to
Order is 7/5/2026.
the order dated order dated
7/5/3.
no, 7/5 is okay. The learned counsel appearing on behalf of the petitioner submits that in pursuance to the order dated 7/5/2026, an affidavit has also been filed. However, the said affidavit has not been brought on record. List this matter again next week. Next week, give a date. Whereby the registry is directed to bring on record the said affidavit which have been filed by the petitioner in pursuance to the order dated 7/5/2026.
For orders, item number 11.
Yes, Mr. Counsel.
It's not office, anticipate the affidavit, also, you know, another thing. I pay for 2 more 75. All right,
You file affidavit. You want to file reply.
Yes.
Counsel appearing on behalf of the petitioner submits that he requires 2 weeks' time to file the reply. Considering the above, this matter again on 19th of June 2026. In the meantime, the reply be filed on behalf of the petitioner. Now, list the matter on 19th of June for admission. In the meantime, the reply be filed on behalf of the petitioner.
History is related to not with regard to the.
Wherever that your petition is not maintainable, you are asking for further inmate. If I was the case today, I don't want on an orders matter to dismiss it. On the date of issuance of notice also, I was very reluctant to do so.
But I think it's still operational for effect.
By admission.
For orders, item numbers 23 and 24.
What are these?
Lordship,
What are these matters?
Lordship, the division bench has a divergent view. Refer to the Chief Justice and it's the. So I think
The Chief Justice on the administrative side had laid the matter before me
yes.
specifically.
Mm.
So
And then maybe
the matter has to be heard.
yes.
Okay, my lords, I am also appearing for one of the appellants.
Yeah.
I beg to appear, my lords. My lord, this matter will have to be heard for some time. It will take at least an hour or 2, my lord.
I am here only to look into it. Either of which judgment should I follow?
Yes, my lord.
And can I
So, my
give-
lord,
No, Mr. Counsel, can I give a third opinion? In
I-
I can't give a third opinion.
I leave it to my lords.
No.
It has been listed before my lords.
No, Mr. Counsel, the fact remains, this is a I have been endorsed the matter on the basis of section 98 of the CPC. CPC section 98 comes into being when there are two divergent views.
My lords,
One judge has said A, or the other side has said B.
my lords,
I can't come up with a C,
my lords,
isn't it? I can't come up with a C.
my lords.
So my question is only to see as to whether A or B is the right.
Correct. For that, my lords, if my lords permit, we can assist my lords whether this judgment is right or that judgment is right. We will make our submission, then my lords will, my lords certainly take a decision on this aspect. Either way.
Okay, when? Next week? Next week?
Lordship, we are appearing for item
Or my
number
lords, it can be
23.
heard after a week thereafter, my lords. Whichever.
Absolutely no. Next
Very
week,
well.
we'll have it next week. Next Tuesday, we are finishing it off.
Lordship,
Very
with
well.
due respect,
Taking
Lordship, with
into
due
account-
respect,
This court have
Lord-
heard the learned counsels appearing on behalf of the parties and taking into account the administrative order of the Honorable Chief Justice dated 12/5/2026. This is the matter on second, huh?
Next week.
So ask her to appear through this video conferencing link.
Lordship, Lordship, if I may. Lordship,
No.
Lordship, just
We are,
one request.
otherwise you
one
argue,
request.
you still have 45 minutes of time. You want to argue. This court doesn't take such a long time. You
We
argue-
agree, my lords.
Argue the
Lordship,
matter. Okay, argue. There's two divergent views. Let's see. What is the matter about?
My lords are keeping it for next week, my lord, 2nd June.
I'm starting it now.
Very well. If my lords may keep it next week, my lords.
No, we are starting it now. Who is arguing the matter? Who is the appellant?
My lords, we are the appellants, my lords.
Okay, argue. Which view do you support?
My lords, we view this, my lords, we want that, my lords, the directive which is issued by the government should be upheld, my lords. That's our view, my lords.
The council, which view should be you support amongst the two views of Justice Kukon or Justice Habum?
My lords, we support the view. My lords may keep it next week, my lords.
Okay, 1 second.
Second.
Taking into account the order dated 12/5/2026 passed by the learned Chief Justice. By the Honorable Chief Justice on the administrative side, list this matter on 2nd of June 2026 for final disposal.
Oblige.
Oblige, Lordship. So here, item number 13.
Yes. Mr. Counsel, tell me, what do you want to say? Huh?
Council court case, referring on government.
Yes, argue. It's a land ownership matter. It's a simple matter. You argue. I have so much time. How many years of practice you have?
I'm a proxy counsel.
Huh? Oh, proxy counsel. Oh. None appears on behalf of the petitioner on call. Ms. So-and-so appears on so-and-so. So considering the above, for the interest of justice, the matter stands adjourned to be listed again on
Monday.
no Monday, on 8th of June 2026.
For hearing, item number 25.
Oh, yes, you mentioned the matter in the morning, which I couldn't understand. Now tell me. Order dated?
17th March.
Oh, I passed a long order. Okay. Challenger say that the charge order by filing a writ petition demand. Court may bench by the order judgment and order to set aside the charge order and directed the petitioner to be reinstated in service. Petitioner upon his claim entitlement to the back wages on the ground that the charge order was passed. The non-grant of the back will led to the petitioner to file another writ petition dated so and so. Being aggrieved, filed a writ appeal to interfere with the judgment and order passed by the learned bench, but did not hold that the petitioner was not entitled. The learned division bench, on the other hand, held that instead of the court deciding as to the quantum of the back wages for the period from so and so to so and so, it should be best left to the respondent to decide the entitlement in so and so. The appellant number 2 in the appeal, who is the respondent number 2 in the present proceedings, was accordingly directed to make a decision on the question of payment of back wages. The respondent number 3 instead of deciding on what should be the back wages to the applying the law laid down by as well as the order passed by the division bench held that the petitioner was not entitled to a single penny, treating that period when the petitioner was discharged from service from so and so and dies. Either designate the respondent paid an amount of so and so to the petitioner. It is also pertinent to take note that immediately upon payment, the petitioner was again discharged from service by the rider. On demand, the respondent appropriated the entire pensionary benefits which the petitioner was entitled to, but also directed the petitioner to pay an additional amount to pay. This court during the course of a hearing as to whether the order dated has been put to challenge. Submitted the petitioner had filed a contempt application before the non-compliance to the order date. However, in all fairness, you have not challenged the order. Have you filed or not?
As per the liberty granted by this order, the new petition is under consideration. So kindly.
You are to file a writ petition, madam. You cannot challenge an order by way of an additional affidavit. Is under preparation. This preparation is going on for how long? 17/3/2026. You are making what? Even Taj Mahal would be made within this period. Huh? You are not drafting it. You should be drafting it. Then why haven't you drafted it? Next week, bring it. Next week. I will be issuing notice then in your favor. You don't want a favorable order in your favor? Huh? What? You don't want it. So you have not challenged it, so leave was granted, so nothing remains. We therefore hold it there without a challenge to the 13/9/2019 order, we can't help it, isn't it? You will dismiss her petition. Huh?
I want the process of
Time.
so kindly.
You are not interested. What was the point of this court passing such a long, detailed order in your favor? The counsel appearing on behalf of the petitioners submits that the petitioner is yet to assail the order dated 13/9/2019. 13/12/2019, though this court had granted the liberty to do so by an order dated 17/3/2026. It therefore appears that the petitioner have not taken up the matter seriously. Considering the above, is there interim order? You vacate the interim order. Vacate it. Considering the above, list the matter of the 3 weeks.
But
Finished? Yes, Mr. Jami, you are waiting. I was thinking that one matter must be there. Yeah.